Good morning, everyone. We obviously have a lighthouse this morning, but I'm sure people will start to wander in, but we want to try to stay on time, so if it's okay. I'm David Karstens. I'm the moderator for this morning's panel. Our topic is patent strategy, but probably a broader strategy, which is how do you protect your intellectual property rights? And we have our panel, which I'll introduce here. I'm with the law firm of Karstens, Allen, and Gorley. We're located in both Dallas and Denver in the United States. You know, and I realized yesterday during that 5 IR presentation, I forgot to do my own introduction, so I feel like I should have twice the time today for an introduction. So I'd like to start with my childhood, tell you a little bit about where I came from, and no, but we're a firm, we've been around for about 25 years. In terms of my personal background, I have degrees in mechanical engineering and electrical engineering, law degree, MBA. I think of us as a very high quality intellectual property firm. My personal practice is mostly just supervising all the other attorneys, but started off doing patent prosecution. Really over the last 10 years though, I focus more on IP strategy for our clients. In addition to the practice, I also have been teaching for about 30 years at Southern Methodist University School of Law. And probably for the last 20, I've been teaching international IP law. So have spent quite a bit of time on the topic of how do you protect your intellectual property around the world. That said, we've got 2 other panelists with us today. Mona Dagher is the managing director of Dagher IP. Mona was a former examiner at the Egyptian Patent Office. They have offices in Egypt and Dubai, but also are with a focus on all aspects of intellectual property. And then they have the ability to help clients throughout the Middle East. We also have with us Gil Perlberg. Gil is the IP manager for Camtech, which is near Tel Aviv in Israel. He has a long history of supervising research and development teams and crafting intellectual property strategy for his companies. So with that, we're going to present different points of view on IP strategy and patent strategy in particular. This is just one process. There are obviously different processes, but this is one that we try to live by. And so you'll notice on our first slide here, we're talking about kind of the big process. One of the first steps, and we're going to talk about each of these 7 steps in a little bit more detail, but it's perhaps the most overlooked, which is have you created an environment of innovation and disclosure? A lot of times corporations will talk about the importance of being innovative, but one of the problems is they don't necessarily get that message all the way down into the core of the organization. And sometimes they also fail to create the importance of disclosing the ideas. You know, it's important to have a certain amount of speed to both development and disclosure of the ideas. Next, we try to get some refinement of innovative ideas that have surfaced by the creation of collaboration teams. Now, the team doesn't have to necessarily be very large, but the team should in fact have at least some people who have some experience in how to refine ideas. Sometimes the initial idea is rough. Sometimes that initial idea is needing some refinement. But that said, if you have a collaboration team, many times you can improve it for the benefit of the company. Third, we have a scoring process where we try to score ideas because no one has an unlimited budget. And so by scoring, we tend to rank and prioritize ideas. We'll talk about that in a little more detail. Fourth, we try to get a good understanding of the prior art. Not necessarily a perfect understanding of the prior art, but certainly some understanding of the prior art. And of course, those are the obstacles that keep you from being able to get the patents. Next, we have to review budgets. Because budgets obviously constrain everything. In the best of all worlds, we'd say, yes, try to patent everything all the time, everywhere. but that's simply unrealistic. So in fact, budgets, have a great deal to do with geographic scope of your protection. Finally, preparation and filing. And then finally, monitoring and reevaluation. It's easy to kind of almost think of these things as a balloon that you let go and it just floats away. And that can't be the right attitude. You've got to keep an eye on all of these filings to ensure that they're still relevant to the client or to the company. So creating the environment is essential. There are a lot of companies where employees don't really recognize that it's okay to make suggestions. They're tied in with their job, and of course they're busy with their job. But I think it's important to make sure that the entire organization, not just the engineering staff, but we like to see everybody in an organization engaged in proposing ideas for changes. That might be changes to products, improvements to products. It might be changes to internal processes. Sometimes there are lots of little innovations that just deal with how the company is organized and operates. Maybe to the marketing efforts. And maybe it's some sort of blue sky vision for something entirely new. Maybe somebody has an idea that doesn't fit into the normal product scope of the company. And yet they understand that it's important to at least surface that idea and allow management to make a decision about whether it's worth going forward with. Part of creating an environment also is how are employees incentivized? Now, I know I've seen a lot of different plans in place. Maybe they get a little money up front, maybe they get recognition, maybe they get money if something issues. Sometimes they get to share even in royalty proceeds if in fact the intellectual property gets monetized. I know, for instance, one of our situations is a large university in Texas, where if there's royalties off of a medical device, for instance, half the money goes to the university system, half the money goes and is split between the inventors and their labs. So about 25% goes into funding a lab that helped perform the research. I always have thought that's a fairly clever and fairly generous way of handling it within a university setting. One of the issues also, I think, with creating an environment for innovation is to ensure that the organization understands the strategic vision of the organization. Does it understand where it plans on going? Again, many times organizations are static and only the people in the executive suite have an idea of what they'd like to evolve into. It's important to push those ideas down so everyone can start thinking about those the changes it'll take to get there. And then finally, do they have the tools to make it easy to submit ideas to the company? Our law firm has actually developed a software tool called Doxile, D-O-X-I-L-E, which is simply a collaboration platform. And it's a system that allows a company to set up a secure area, and the innovators at the company can then simply upload notes. And then once those notes are uploaded, collaboration teams can be established, the notes can be refined, and ultimately they get moved forward toward patentability or they get archived. But again, the goal is speed. It's not about letting something percolate for 5 years and then making a decision. The idea is get it surfaced, get it evaluated, and then either move forward or stop. There's nothing wrong with stopping. Sometimes the idea is not a good idea. Sometimes it doesn't fit. So, talking about the collaboration team, I was very happy about finding this graphic. I thought it was a clever little graphic. So, how do you establish good collaboration teams? I think of all of this as a team sport. And that team is usually internal personnel, but it's good to have a process by which you establish a good internal team. Sometimes the innovator, the person with the idea, is junior. well, it's a good idea to try to put them with somebody senior then, somebody who's been through the process enough times. You know, a lot of times junior members have great ideas, but have absolutely no idea what to do. They don't know how to even fill out forms. They don't even know how to articulate what the idea is. Again, if you can get them into a team, it's more likely that that idea will be articulated properly. Sometimes that team might include outside advisors, patent attorneys, for instance. Patent attorney, sometimes who's had a lot of experience, can do a lot in terms of guiding and broadening an idea. Sometimes it might be a business advisor. But either way, it's important to try to encourage companies to establish these teams. Here's one where I actually hand drew the graphic, if you can't tell. This is just my sketching. We try to score things. You know, and it's not just scoring it in a simple fashion, although there's nothing wrong with that. You know, in some cases we simply say, okay, this is an A or a B or a C. You know, A ideas get more attention, B's and C's less attention. We try to do it across more metrics than just that. You know, we talk about, well, is it even patentable? But probably the two most important scores that we look at are how much do we know about what customers might want? And then secondly, how well do we understand our own core competencies to determine if we can actually implement this? Can we actually execute on the idea? Now, if you look at my little hand sketch there, it's hard to tell, but there's an x-axis and a y-axis. The x-axis in this case was knowledge of customer needs. No one has perfect understanding of what a customer might want. But if you'll notice the intercept between the x and y-axis, you'll notice the number is 100 for each of those. And we just put it on a 100-point scale. You know, in the best of all worlds, you have perfect knowledge of what your customers want, and it's right up your alley. You know you can do it, okay? So the y-axis is the ability of your company to actually implement. Okay, in that situation, you're at the intercept, 100 for both. That's kind of rare, but the point is, as you understand less about what customers want in the future, less about whether you can actually implement, you kind of go up and outwards on this graph. And so you'll notice I've drawn in a couple of curves, which I call innovation horizons. So there's the H1 horizon, the H2 horizon, the H3 horizon. There's nothing magic. If you want to just have 2 horizons, that's fine. If you want to have 5, you can do that. But that said, I do this just because it helps me understand if something falls within the H1 horizon, that means I have quite a bit of certainty that in fact a customer wants it. Okay? There's going to be a market, there's a product market fit. Secondly, though, I'll look at, is it something we're pretty sure we can do? Okay, in those cases, you know, I have a high score on both of those axes. I'm closer to the intercept. I'm probably well within the H1 horizon for innovation. Now, that's wonderful because chances are it's going to be a successful product. That's a good thing. But it may be harder to patent because, of course, to get a patent, you have to prove both novelty and inventiveness or non-obviousness. Stuff that is already obvious to you is something that can be done and that's likely to be successful. It's going to be a lot harder to demonstrate that as a non-obvious and inventive idea. So you may very well not be able to patent it. Just as importantly, you probably have to have a better understanding of the prior art because it's likely your competitors have also thought of the same thing or something very similar. So again, that's one of the benefits of graphing out where you fall on the innovation map here. And I've drawn these little dots just to kind of demonstrate where data points might land. You'll notice some of them kind of land outside that first curve. We typically view that as kind of second horizon innovation. Now, if it's a second horizon innovation, you have a lot less certainty. Maybe customers don't want this. You know, maybe it won't be successful. Maybe there's not product market fit. Maybe we'll have a hard time innovating. Maybe we'll actually have a hard time reducing this to practice. And yet, you have some certainty probably one of those is true, okay? This is probably the sweet point in terms of being able to have a patent strategy built around innovation. It's probably the stuff that lands in what we call the H2 horizon. Finally, stuff that's outside of that, you have very little understanding of the market. You have very little understanding of whether you could do it. But these are kind of blue sky ideas. Sometimes you have to put a bet on that. Sometimes that's what we consider disruptive technology. It's something that you haven't anticipated that in fact might be very, very successful. So in fact, I think it's always important to then look at where this stuff scores out, where it lands on the innovation graph, and then make some decision about how you're going to allocate your funds to protect it. So it's a lot to digest, but it needs to be some spread across those. Now, the ones that we call as H3 or kind of blue sky ideas, almost always you've got to have upper management agree that in fact this is within the strategic path of the company and how it wants to innovate toward the future. So our next slide, innovation, vision, and prior art. We've talked a little bit about how the H1, H2, and H3 horizons help guide you in terms of where you might allocate your funds. And by the way, this is all about kind of external innovation because, of course, it involves customer understanding. Customers don't necessarily matter. They don't necessarily care about how your internal processes are run. But for product and service development, I think this is a good model. So even when you do all this, you still have to have some understanding of the prior art. You may find that you have a wonderful blue sky idea that really ties in with the vision of management, and yet it's already part of the prior art. Better to learn that early than late. So, important to understand prior art. Prior art, kind of roughly speaking, is anything that's been disclosed in a written document that predates the filing of your application. Ergo, it's important to get early filing dates because there's less prior art. Every day there's new innovation. It's impossible to have perfect knowledge of prior art. You know, we always remind clients of this. We may look, and what we really obtain is a confidence level. We might have a 60% confidence level that we understand what's out there. But no one is omniscient. No one has perfect knowledge. Everything is done with risk that, in fact, prior art will arise. But it doesn't mean you don't want to look. So how much you look, though, and how much budget you allocate is an important question. Do you allocate an enormous amount of budget to prior art searches for something in the H1 area? Well, that's a judgment call. That said, it's also important to make sure clients are sensitive to the difference between patentability and infringement. When we do prior art searches, you know, you have to understand and have at least a reasonable understanding of the disclosure for purposes of patentability, because that's what determines novelty and non-obviousness. However, it's also important, especially if you're going to be in that H1 area, to do a more thorough understanding of the claims of the prior art, because of course that's what determines whether that product is going to be an infringement or not, or infringe somebody's earlier patent. So, important to sensitize the client to the difference. A lot of times clients are sophisticated and yet they still miss this point. Okay, budget. Single most important thing. How big is the budget for patent filing? How is it split? Is it split between new matters and new filings and maintenance? Can you get extra budget for important cases? Can you steal budget from the marketing budget for the R&D? That's what we always recommend. Steal it from marketing. So without a better understanding of how much a company can invest, a lot of times you'll end up doing a lot of work and then find that really you can only go forward with a very few cases. But you've got to know what that budget is. So where should you file? Uh, kind of a rule of thumb we look at. Well, where are the customers? A patent gives you the right to stop others from making, using, selling, offering to sell an infringing product. If an infringer's out there, you want to at least know that he's probably trying to sell to the same customers as yours. And so it's important to get patent protection where the customers are located. Second thing is we'll look at where are the main competitors? Where do they have their manufacturing facilities? Okay? Again, that's a rich target for filing. And then one of the third areas that we'll look at is where did infringing goods transit? So for instance, there's a huge airport very close to us right now. A lot of goods come in through that. There are 3 main ports, I believe, in Dubai where infringing goods come in from China. It's important to understand how do the goods enter into the market. And so if the market is the Middle East, well, they're probably coming in by ship. Well, where are the main ports for those ships? That would be a place you might consider doing a filing. Finally, prepare, file, and prosecute. Okay? This is what most of you are already familiar with, so I won't belabor it. Always make sure you understand what deadlines might exist. Was there already a disclosure of the idea outside the company? If there was, just assume that you're fighting a ticking clock and you've got to get your application on file, or possibly it's already too late. If there have been disclosures, go ahead and try to get them documented. There are lots of subtle arguments that can be made about whether something's really on sale, whether something's really been publicly disclosed. Make sure that your patent attorney or the agent has kind of the appropriate level of experience and technical background to understand the invention. Try to be sensitive to the claim. The claim language that's being drafted is really the most important part of the patent and the value that you have. And of course, I've got the little graphic here showing that there's a balancing act. Everyone would like to have the broadest possible claims, but of course, the broader you make them, the less likely it is that they'll be novel and define a novel invention. Also, understand that there are subject matter issues. Some countries, some regions won't allow certain types of patent claims for certain types of subject matter. Finally, monitor and reevaluate. These are not balloons that you let go of and let them drift in the air and drift away. You've got to keep an eye on them. You've got to constantly be going back and asking, is this still a relevant matter? And that's not just about current cases or brand new applications that are being filed. It also deals with your existing portfolio. A lot of times companies just they go on autopilot and they just keep paying maintenance fees on a wide variety of patents that may no longer be relevant anyway to the company's goals. That's wasted money that could be spent somewhere else. This is a tough one, but sometimes we'll try to look at whether you can attach a return on investment to a patent or to a portfolio. A lot of times companies will make financial decisions based upon minimum ROI. So our goal is to at least establish that some portion of the patent practice has exceeded that minimum ROI. Likewise, there are services that help with the valuation of patents. Now, accounting rules don't always let you put that stuff on balance sheets. Sometimes it does. Either way, it's something to consider at least, is establishing some sort of a valuation on the portfolio. There are automated systems right now. We look at one right now called PatSnap. Again, it's kind of a wild guess, but they have a kind of an automated process of looking and creating a valuation on patents. Sometimes it's at least a good starting spot. Helps you identify key patents within a portfolio based upon its analysis. I'm going to go ahead and hand off now to Mona, but hopefully this was worthwhile and gave you some new ideas. Mona?
Yes. Hi, good morning, everybody. Thank you, the organizer, for giving me this opportunity, and thank you, David, for introducing me. I am Mona Dager, the Managing Director of Dar Intellectual Property. Let's take the discussion to another point of view, the balance between the perspective of the patent examiner and the perspective of patent agent in safeguarding of your creation's rights. To take the patent disclosure decision, it is important for the inventors to know when and how to disclose his invention. Inventors often need to disclose their ideas to secure money for manufacturing of their products, to efficiently using of their inventions, or even to get the promotion and extra. But without property right, the inventor will not likely to make the full disclosing of his idea to avoid the wrongly benefiting by others from his product. So the two opposite sides are the desire to disclose information and the need to limit access and use without the inventor's authorization. Patent protection versus trade secret, and disclosure versus secret. As we know, the patentable requirements need to be met is the novelty. The invention is new, it is not anticipated by the prior art, inventive step, non-obviousness, and industrial applicability and disclosure of the invention. The invention is sufficiently disclosed in the application. Okay. Let's take the pharmaceutical patents as an example how to take such decision. The development of drug from the lab to the shelf takes around 12 years to 15 years. This drug development costs about billions of dollars along to reach the optimum compound of this drug. How to protect such investment, patents, or trade secret? How to earn back this investment, monopoly versus competitions? Okay. So, in order to take such decision, it is important for the inventors to go through the patent search. Patent search is the valuable tool that gives the inventor the chance to hit the cracks and go back to drawing board before it's too late. Such tool helps the inventors and innovators to a great extent in saving money, time, efforts, and avoiding the common hassles involved in the patent prosecution. As you know, the patent prosecution takes around 3 to 5 years in order to get the patent grant. Commonly, the inventors wish to drive straight into the patent application process. They believe that since the invention is not there in the market yet, it automatically meets the patentability requirements. Unfortunately, this is not the scenario. With the huge number of patents granting around the world, only small fraction of patent grant already reach the market. Why? Because the inventor fails in addressing the feature of his invention during the patent research, disclosure, or evaluation, protection, and marketing stages. And because the increase of number of patent applications filed every year around the world. Not all patent applications also filed are successfully in receiving patent grant, especially in the Middle East. Importance of the analysis of the invention patentability criteria in the jurisdictions. Let's say that the patent application subject matter is directed to use of a medical compound in treatment of whatever the disease. Okay. And my target jurisdiction is Saudi Arabia. So, in order to get your patent grant, you have to make analysis or studying about the patentability criteria of Saudi Arabia. Some subject matters are not allowed to be patentable in Saudi Arabia. The second use, all use claims are not patentable in Saudi Arabia. The same in Egypt, but in GCC office, the regulation make the patentability of the use is allowed. So you have to study the excluded matter from the patentability in the target jurisdiction, and also the eligibility of the invention subject matter to be patentable in the target jurisdictions. Importance of claim drafting. As a patent agent, the most important item in the patent is claims, which is the boundaries of invention protection. So claims drafting makes the invention novel or infringing other valid patent. The most important thing in the claims is phrasing the claim to be specific as possible. The balance between the full disclosure and keeping the know-how of the claims as a secret in order to give client broad protection and in the same time to make the examiner comfortable with the phrasing of the claim as a full disclosure. Thank you for your attention. Thank you. We're now with.
Thank you. Hi, good morning. My name is Gil Perlberg. I'm the IP manager at Comtech, a semiconductor company in Israel, manufacturing semiconductor inspection equipment. And I'm one of the few in the crowd, I think, that's not a lawyer. I came to IP management through management, and later on to IP. And what I want to discuss today is how IP interacts with the business. And what you have here is what's called a business model canvas, which is a graphical way of looking at the business plan. We have customers, we have partners, we have revenue streams. All aspects of the business can be described and discussed with this map. And what I want to suggest is that we should have an IP business model canvas. Where does IP help us? First of all, it helps us protect our revenue stream through monopolies. But there's a lot of other aspects of the business that IP should and could contribute. One and foremost, trade secrets. Second thing is to protect our competitive advantage. That's one of the goals. Another thing is we have to identify what our IP customers are. When we have registered IP, as mentioned here, you have to think of the jurisdiction, You have to think of the competitors. Just protecting your product, having a monopoly, might not aid the business. It should go to a customer. It's a product. And if you don't have a customer at the end, it's worthless. We don't talk a lot, but there's a lot of IP-related risks. Somebody can put a patent out there that would bother us. Somebody could invalidate our patent. There's a lot of other IP risks that we should take into considerations that in my mind don't get enough attention. I won't go into the whole circle, but I have for every one of them another piece of topic we can discuss. So IP is usually thought about registered IP with a focus on how to get registered IP better. In my experience, it does not suffice. I want to take some time to discuss trade secrets. And before that, I'll tell you a short personal story. A few years ago, I took up sailing. And I took a skipper's course a few months long. And towards the end, there was an exercise, and the instructor told me, go into the sport. And I started doing what he said, and he looked at me, and he was about half my age. And he was looking at me with the look of somebody who knows something that I don't know. And he said, before you go further, why don't you stop the boat and put it here, and we'll discuss something. And I put it in what he called the safe waters. And he said, there's a process we have to follow. You're going into uncharted territories. You have to look at a map. You have to analyze the situation. Then you have to plan. Which dock are you going to? Once you go in, you can't go back. Then you have to prepare. Maybe call the docket master. Maybe have the ropes ready. Maybe know who's going to throw the rope. Only after you've done the analysis, plan, and preparation do you go on. Now, this is not about IP. This is for life, right? But when we do registered IP, do we do all the analysis and thinking? And the first thing I do is I like to look at what are the assets I have. And the assets are typically described like a glacier, patents on top, public, everybody can see them. Everything's known and well-defined. And there's the trade secrets, which is most of the know-how, most of the value of the IP assets of the company. And it's murky. What are the trade secrets? They also change all the time, and their value fluctuates. But if I want to monetize my IP, like was discussed yesterday, where's the money? I would like to bring a package, not just a patent. And the package is the registered IP and the know-how, how to use it to make money further down the road, and how to avoid the risks. So this is one part of the situation analysis. What are my assets? The other part of the situation analysis, what do I want as a business? Am I a licensing company? Or am I a company that develops really fast and a technology that's changing really fast, and that patents are not necessarily the key tool, but I want to protect my IP? So for the licensing and the rapid R&D, there's template answers. The licensing, it's very critical to have a good IP portfolio, a broad IP portfolio, robust one. It will have to go through due diligence. And the rapid R&D, sometimes the people involved don't know a whole lot about IP. I would invest minimal amount to put something defensive up to avoid the risks. But the biggest group is in the middle, from my experience. I talk to CEOs who tell me, we don't know what we want to do with our IP yet. Let's postpone this discussion until the product is in the market, until we have some revenue. They don't understand that it's too late, because you can't go back in time to get the priority date. Once the know-how is out, you can't protect it. So timing is key in IP protection, and timing is strategic. And this is something we have to realize when we're talking about how are we building our IP portfolio. The other thing is we have to think about our goal. A lot of the discussion about IP is legalistic. how do I go to court and get back what I want to, what's taken away from me? The goal is to protect it so you won't have to go to court. If the IP is clearly yours, well done, well put, it won't be challenged. If it's mediocre, people will take advantage of it. Going to court is a lose-lose proposition. So staying within the competitive edge is key. I want to give you an example, a case study of a topic to make the discussion more concrete. We talk a lot about innovation, and everybody praises the importance of innovation. And many people have innovations, many companies, innovation managers, and do innovation projects. And the premise is that innovation creates IP assets that provide competitive advantage. And the second truism is that protected IP assets are much more valuable than non-protected IP assets. I think you'll agree with me. So I want to go with you through an exercise of an innovation session at a company. I've managed many innovation sessions like this. It can span 5 hours or 5 days. They look very similar. And they have very similar characteristics. I want to discuss it with you. We start usually with a problem. Management comes up with a problem. We need to innovate around something that we haven't been able to do. If it's something we were able to do, it wouldn't be a talk of an innovation session. So the problem is interesting already. Then you get people together in a room, you do some preparation, and you sometimes have an external facilitator, and you come up with a lot of ideas, solutions. You also identify maybe other problems that are relevant to the company, to the industry. Coming out of this discussion, these discussions are a lot of fun. People come excited out of them. And then there's a list of things, ideas. And then somebody who's managing this has to decide we can't do everything. We're going to choose one or two. How are we going to choose one or two? David showed us a criteria decision matrix. It could be for many reasons. It's the best idea out there. It could be it's the best idea for us now. Why? Because we have legacy problems. It's the best idea because we can attack a competitor. So there's different ideas, way to decide what's the best idea. But typically, once it's decided, once we analyze the space, after the focus, we go on to develop the idea, and then to produce it and manufacture it and sell it. So when we look at the solution space, we usually take one or two of the best ideas, and we file for patent protection. We do. And usually, in time space, close to the idea, close to the time of the brainstorming session. But only when you start working on them do the innovations really happen. Because up till now, it was a thought exercise. People came up with ideas. Now you have to make it or do something with it. That's where innovation usually kicks in, or where enablement kicks in. Up till now, we were just talking ideas. And as we go down the chain of making this into a product, there's typically many, many more innovations because there's problems, and the problems are solved, and there are potentially patents. There are definitely intellectual property assets. So the innovations are intellectual property assets. I would argue that the problem I started with is an intellectual property asset of the company. It doesn't want everybody in the world to know I'm dealing with this problem now, and actually I'm having trouble with it. So that's something I want to keep secret. That's my property. And if I came up with a list of other problems, they're also mine. I don't need to share them with the whole world. If I don't protect it and share it, I don't have a competitive advantage. So the first takeaway I took from this, and this is something that's evolved with me for a few years, is I need an IP asset management system. I need to know what are my IP assets. And my IP assets are not only what's visible at the top of the iceberg or what's registered. There's a lot more involved. and I need to have an inventory of them. I want to go slightly deeper into this patent that they've made at the end of the brainstorming session. What did I patent? The solution I chose? Maybe all of them? Do I write a patent application for 20 ideas or 20 patent applications? I can tell you with guarantee, with certainty, a year later, you're going to have a lot more patents, potentially, that came out of this brainstorming session as you developed and evolved. Because I know it, I can plan for it. I can budget for it. And I know what I need to do, maybe. So I need to use tools that can help me manage my budget, my resources. By the way, budget in this case, it's not only dollars. What I found is often more valuable is the inventor's time and attention. Because to get him involved and continuously is key, and it's very scarce, and it's very expensive. So at the beginning of this process, I can already try to discuss, this is going to be my plan 3 years down the road for managing the patenting process and budget. And there's no surprises. I've done this many times. It sways a little bit, but after the first patent, there's going to be more down the road coming from it. If you're in tune with the development, going back to what David was saying about how to get all the ideas. But what do we do about the non-patentable IP assets, like the problem? Well, there's trade secrets. But trade secrets is easy to say and hard to do. And the first thing we have to realize about trade secrets, it's not an event. A patent is an event that happens. There's a dialogue between an inventor, a patent attorney, it's filed, a couple of people do something, and then there's a date. A trade secret is never ending, and it involves many people and many topics. And it's hard to grab. It's not something tangible that I can talk about. Let's take an example. I have a technology development effort going on. It has basically two thrusts, hardware and software. And they keep everything while it's in the realm of a development as a trade secret. The team knows not to talk. There's 24 people involved, and it happens in a closed environment. And then we decide that we need to show some of the stuff, specifically things related to hardware, to investors, to strategic investors, at a show. So we patent some of the features of the hardware. But notice that the other stuff remains a trade secret. After we patent it, and as I said, it's a one-time event, development continues. So we keep more trade secrets. Even though we patented it, there's a whole bunch of other trade secrets going about. And there's a lot of other trade secrets around this invention that we need to keep. So the question is not, do I patent or do I keep something as a trade secret? Because there's no trade-off here. Trade secrets are a must. They're always around us if we want to have a healthy business and maintain our competitive advantage. A patent is my decision when and how. So let's talk a little bit about definitions. A trade secret is information that is generally not known in public. And I've highlighted the generally because unlike with patents, if there's a prior art, it's not patentable. The courts have not given clear boundaries for generally. If 3 people outside of you know it, it could still be a trade secret. If it's on the internet, it's probably not. But the word generally is not well defined. It's a trade secret if it has value. We don't care about things that have no business value. And this is the trickiest one of all. It's only a trade secret if the holder has made reasonable efforts to protect it. If you don't protect it, then obviously it's not important. If it's not important, why define it as a trade secret? This description is good for our audience here, mostly lawyers, but when I talk about this with work, companies, employees, I have a very simple rule. A trade secret, anything you don't want your competitor to know about us. Let's don't talk. Doesn't matter if it's confidential, trade secret, what the definition is. If it's something that would not be in the benefit of the company, if the competitor knew about it, keep it to ourselves. One of the parts with trade secrets is conveying it to the group and team. And how to do that, if you start with the legalistic, you won't go very far. The eyes glaze very fast. You have to give very simple rules that can be very simply enforced and discussed. I want to tell you a personal story. I was working a few years ago at a small company that had a very unique technology, very few patents. And I replaced the VP of R&D who had left a few days before, and the owner asked me to assume the position. And it turned out that the VP that resigned didn't just resign to go on vacation. He opened up a competing business. Not nice, right? And the owner of the company sued him for what? Trade secret theft. He knew everything about the company. He was taking this know-how, opening up a competing business with the same customers, same vendors, same everything. And he took him to court. And we had a judicial meeting, preliminary, with somebody appointed by a court. The VP that resigned, I'll call him the thief, and his lawyer. Our lawyer, the owner, and myself, and there was somebody presiding over the meeting, somebody the court appointed. And the thief's lawyer asked me, what were the trade secrets that were stolen? And I immediately said everything. Processes, designs, future plans, customer lists, pricing, vendors, and I went on and on, everything about the company he knew, and he took, and he's probably using. Person presiding over the meeting asked me, Mr. Prober, what exactly were the trade secrets? Everything is not a good answer. And were they protected as trade secrets? And I didn't know what to do. I had no answer. I looked at the owner, we both shrugged our shoulders. The meeting ended. The person presiding over the meeting said, we came here to talk about trade secret theft. It seems that there were no trade secrets, so the meeting was adjourned. So this is a lesson that I took from this. Hopefully not to make it happen to anybody else. And the lesson is very simple. If you don't treat it as a trade secret, if you don't do what's necessary, the courts won't help you either. And you have to do and understand what's needed to be done. And I share this story wherever I go. Hopefully other people won't fall into this trap. So what is trade secret protection? What's reasonable efforts? The courts don't define reasonable efforts very clearly. There's no guiding rules about this. There is one simple rule: if you don't do anything, like what happened to me, you didn't pass the reasonable efforts. How much do you go up the staircase is up to you. The classic example is Coca-Cola. 4 people know the secret, never traveled together, never on a plane together, etc., etc. Don't know if it's true, it's a good story. The secret is around for over 100 years. We don't want to do that, but we want to do reasonable efforts. The first reasonable effort is to mark your information that's confidential as confidential. Put the marking. If you have an email, write on the footer, this is confidential. If you did all the rest that didn't do that, you left the door open, because we share a lot of information through emails. Have some physical security. Somebody comes and visits your offices, your labs. Have a couple of locks. Have a guard, have a camera. Do something that will reinforce the security measures that you have to rise to reasonable levels. So when somebody asks you, are these trade secrets protected, you could immediately say, of course. This is how. if you do this, hold a brainstorming session in the hallway in front of everybody who's visiting, and it's probably not reasonable efforts. The problem with reasonable efforts is more, it sounds simple, but it's very hard actually. There was a case where a company licensed technology and brought in people to a conference to talk about the licensing and the technology. And they had about 100 people come into the conference. And they sent them all NDAs ahead of time. And 95 people signed the NDA. 5 didn't. Okay. A little while later, somebody infringes or disrespects the NDA and shares the information with other people. And they sue him. You are under an NDA. But the NDA specifically says that it's confidential as long as it doesn't go into public. And the 5 people that did not sign the NDA were not obliged to keep it, and they made it public. Everybody can make it public. So closing the gate a little bit is not enough. You have to do it good. So we'll come back to this point again in a minute. When you analyze, and this is through research, through case studies, and through my readings in the internet and of other people who deal with trade secrets and trade secret cases, most of the problems occur because of employees. We tend to look for cyber, we tend to look for technology. I'm not dismissing that. Most of the problems are employees. And the problem is that employees don't understand what's a trade secret, what is the company's trade secrets, what is allowed, what is not allowed. If we don't give them the training, if we don't give them the guidance, we can't expect them to keep the trade secrets. It happens out of ignorance. It's shared and it's gone. The second bullet is harder. Sometimes we do business with vendors, with third parties, with potential customers, whatever. We have to share confidential information. We have to share trade secrets. That's why we signed the NDA. But sharing of confidential information should be done delicately, carefully, thoughtfully. It doesn't mean that because we have an NDA, everything is open. So working with the teams and advising them, yes, we have an NDA. Not everything is allowed to say under the NDA. There's still information we do not share. Even as we share information under the NDA, we do it gradually, only when needed. We give them guidelines. And we document what we share. So we need to look at the people and our processes and regular work environment to protect our trade secrets. It's not like a patent. If you do what's called a situation analysis, you say life is getting more complex with respect to trade secrets. There's a lot more mobility of employees. There's a lot more communication. There's a lot of more opportunities for people to make mistakes and share trade secrets unintentionally or through ignorance. Also, through cyber, etc. But we have to raise the importance of trade secrets if you want to keep our competitive advantage. And, by the way, also the registered IP, patents. If somebody proves that we share the information ahead of the priority date, the patent can be invalidated. And it's very easy to track and time these things these days. So we have to be more alert of that. Now, when I advise employees, and management for that matter, what is the trade secret? How do we decide what is a trade secret and what is not? I have a very simple rule. If it's in the sunlight, if it's in the web, if it's on our annual report, if it's in the presentation that the CEO made on YouTube to investors, it's not a trade secret. All the rest is confidential. We don't want people starting to think, is this a trade secret, is it not? I heard somebody discussing it at lunch when there were guests around. Maybe that somebody had the authority to discuss it or knew something you didn't know about Andy. For most of us, if it's not in the sunlight, it's not ours to share. That's the simple rule I give people. And that addresses generally. Now, everybody I talk to when I go to a new company, when I talk to CEOs or patent managers, do you have IP protection? Everybody says yes. And everybody does. Everybody has some form of protection. The question that needs to be asked is, do you have effective protection? And that's not necessarily something that you can answer off the bat, because it takes a little bit more thinking. What I've come to do is, with other peers and partners, is to develop a 360-degree system, a holistic system, that talks about procedures in-house. That's the top one. It talks about legal documents. For example, explaining to people the legal documents. The legal documents is the NDA maybe, or the employment contract that has a confidentiality clause. We have to bring and alert the employees or whoever signs it, this is what we're talking about. And we have to have the confidential information clearly marked. Otherwise, there is no confidential information. How could anybody know what's confidential if we don't tell them what's confidential? There's a lot of cyber issues that fall under this. Some of the cyber issues is purely technological, but some of this is habits of how we use IT. I came to this meeting, I shared a link in order to get the presentation up. I don't put a USB chip into a computer that's not mine, and I don't send by email. Only in the past few years. Years ago, I would do all of them. Getting worse and worse. We have to think and be proactively safe. We have to provide a lot of training. Training is a must, but what I usually tell people, I think training is totally irrelevant if done once. Training has to be repeated, and then it sinks in. Most employees in companies that I've worked with go through an orientation week. They go through a week of training. If you ask them after that week what they remember, very close to zero. If this is important to us, we have to repeat it. And that leads to the last bullet, which is awareness. Creating a culture of awareness to trade secrets, to IP, is a very challenging enterprise. And it has to be throughout, all the time, everybody. That's where I spend most of my time these days. It's very small steps and repeated trainings. So I want to invite you all to discuss, and I'm happy to discuss with you today or later, how we can innovate IP so it has a greater contribution to the business, and how we can innovate the IP protection of our innovations. Thank you.
Well, we'll open up a few questions. I know it's early in the morning. All right. Well, certainly we'll be available afterwards. So if you think of something, feel free to ask.
All right, thank you so much, our panelists and moderator, and we'll now hand over the mementos. Starting our session now. This is the session 2 of the day, and it is brand protection and security challenges and securing your IP. And I'll be moderating this session. Our panelists are Priya Rao. She's the founder at Priya Rao and Associates, India. Priya is the founder of the firm. For the last 2 decades, she has advised and represented several Fortune 500 companies in India and internationally. In her career of over 24 years, she has handled several matters including company law, tax law, anti-dumping law, intellectual property, family law, arbitration law, and wrote petitions for clients across the globe. She joined the profession in the year 1998 and started her practice at Chambers of Supreme Court Advocate. Priya also specializes in IP since 1999. Over the years, she has handled all aspects of prosecution and enforcement of trademarks, copyrights, geographical indications, and design. Our second panelist is Kamal Sharma, Director and Assistant General Counsel, AMA West, IMEA, Procter & Gamble's UAE. Kamal is responsible for designing and implementing the company's strategy to fight counterfeit and protect P&G's product portfolio across the IMEA region. Kamal has over 16 years of experience dealing with critical IPR-related issues and conflicts that are detrimental to the business and kicking off enforcement proceedings against IPR infringement and counterfeit. Prior to P&G, Kamal has worked with a top-tier IP law firm advising and counseling clients across industries like FMCG, automobiles, healthcare, etc. on litigations involving trademark, copyrights, and designs. Kamal is a strong advocate of protecting retailers and consumers from counterfeiters and counterfeit products and has been leading these discussions across various committees and fora. Now, I would request Priya to start her presentation and take over from here.
Good morning, everybody. And thank you so much for the introduction, Azam. And it's a great honor today to speak on IP protection, particularly on brand protection in India. So my presentation is going to be what can be protected in India as your brand, and at the same time, how you can enforce it. So before I start the presentation, everybody in this group, in this hall, I think if you're talking about India, I think as a lawyer, as a brand owner, you'll be concerned whether you can protect your mark in India. I think before I start my presentation, I should confirm it to you that if you're the owner, you have a brand in India, the laws are so robust and there is no national bias, you can protect your mark in India. The enforcement laws and the protection laws are very, very friendly to protection of a brand and brand owners' rights. And it's not very expensive and it's not very time consuming. So let's start by first identifying and recognizing this before I move forward. Okay, so in India, let's see the way we can protect your mark. Everything that is traditional mark and non-traditional mark, both are protectable in India. So anything, for example, when we talk about traditional mark, we talk about word mark, logos, names, numerals, signature, slogan. Non-traditional marks such as shape of product, sound marks, they are all protectable. Color combinations, any combination of this listed in the slide is protectable in India. Also, smell mark, which is non-traditional. There has been, when we file the application, there is a place where we can, if there is smell, the registry is open to smell-related marks, but right now we've not had any example of anybody filing for smell marks. The law in India for when we define what trademark mark can be protected, anything which is graphically representable is protected in India. For example, non-traditional mark like shape of a building, which is not something which is so commonly protected. In India, we do have a registration for shape of a building, which is historically recognized and renowned, has also been protected as a trademark in India. So we haven't had any example of smell, but barring that, everything else is protected. Sound mark, again, graphically it is representable. You can give the notes and it is protected. So we have marks like Yahoo and the Tarzan yell. All these are protected in India. So this is. So I would say it's quite, the definition is very inclusive. It's not exclusive. It's not the other way around. You can have more and as many as you can think as which you can protect in India under the Trademarks Act. Okay, so how do you protect your trademark in India? India is a common law country, which means the use is superior to registration. So if you have, you've adopted a mark honestly, and you have been using it, it's not mandatory to have a registration in India. But if you have a registration in India, it just gives you an extra edge. That means if you can, the proof of ownership is less. So you can, you have a registration certificate, so enforcing it before a court of law or a police officer, a criminal enforcement body is more easy. So, so we would recommend registration. But if you don't have a registration, not everything is lost. If you have prior use, honest prior use, you can still protect your mark. How do you have a registration? You can use a domestic filing. India is also a part of the Madrid Protocol. So you can use even the Madrid route for filing. So if you're based out of Germany, or you're based out of UK, you can also, if you're filing, you can designate India as India, and you can file it through that route. Now now the main question would be, can we enforce the rights in India? Typically, when we talk about infringement or violation of our trademark brand rights, we normally see counterfeiting of goods. We'll see counterfeiting, products being manufactured. We see counterfeit by way of, imports and sale in stores. You see counterfeits being sold on e-commerce platform. A typical example of violations would be, mark which is similar, not so similar, and used for identical goods or not so identical goods to your area of interest. Violation we see on domain names. We see violation maybe on company names, and again, unauthorized import of goods. These are typical broad violation of trademark brand rights. So how are we able to protect these and take action against these kind of violation and protect our rights in India? The next slide will deal with that. So I've actually split the remedies into 4 buckets. So depending on what kind of violation it is, what are we dealing with? We normally have a strategy. Sometimes we pick one, sometimes we pick more in combination of remedies. So 4 that buckets that we have in India that we can use is the civil remedy. We have criminal remedy. There's border enforcement measures, and there are administrative remedies. Now, when we talk about civil remedies, typically any civil action you file these action in civil court. In India, we have 3 levels of courts. That is 3 levels of appeals that we can go. The very basic court is the district court. That's the first court of instance that we call. You file your action in district court, and then it can go to high court, or it can go to, and then after that we go in appeal to Supreme Court. Now, because trademark violation is a commercial dispute, we have a Commercial Courts Act very recently which has come into place. Like yesterday somebody was mentioning, delay has been a concern in many countries. So India also earlier was criticized and had issues about delays. So just to address these delay issue, recently, there's this Commercial Courts Act which had come, whereby even all the IP matters come under the commercial dispute courts, and these are fast-track courts. These are special courts. So every district court, every high court, and every, I would say, Supreme Court, of course, there'll be the bench which takes care of it, but district court and high court, there are specific IP commercial judges who preside on these matters, because these are very specialized area of law. They are trained in these subject. Sometimes they're also judges who have been elevated, who are previously practicing IP law. They come on the bench. They are asked to join the services. So these are all very, IP-friendly courts. So we get reliefs in these courts very easily. Some states in India also have original jurisdiction, which are very IP savvy. There you can go as the first instance. That means that you don't need to go to a district court. You can go directly to the high court and go in appeal, if there is an appeal, to the division bench, and then go to Supreme Court. And some court, these specific courts in India could be Delhi, which has original jurisdiction in high court, will be Delhi, and there will be Mumbai, and popularly Chennai, Madras, and Calcutta. When we talk about trademark infringement action, the basic requirement is that you need to have a registration. If you don't have a registration, the infringement case is not made out. In an infringement case, if the mark is identical, the violator is using identical mark in relation to the identical goods, that is the basic requirement for filing a case under infringement action. Only then, if it is similar, then what is applied is a little slightly different. So in an infringement action, if the mark is identical, you have a registration. The violator is using your identical mark in relation to identical goods or similar goods. Nothing further needs to be proved. A court will injunct the other party. In case it is similar, then once more step is required. We have to establish your reputation. If it is, and if it's not an identical goods, then you have to also, in even those cases, you have to satisfy the court on reputation. Also in India, there is, if your mark is well known, then you can use the well-known provision. For that also, if you don't have a registration, you're a well-known mark in India. For example, Kamal is from P&G, and Gillette, Mach 3. These are all listed as a well-known mark. And even if it was not registered in categories where, which is not related to Gillette, if it's not related to shaving products or male hygiene products, but it's used in relation to a suitcase, we just have to show that it's a well-known listed mark, and an infringement action can be brought, and it's directly an injunction will be given for the asking. In case of dissimilar, like I said, we'll have to prove reputation. Like I said, India is a common law country, which means that, again, use is superior. If you have reputation for the mark, and you have been using the mark in India, if the violator has subsequently started using the mark, you can actually bring an action against that party and also get some injunction relief in these cases. What you need to establish in case of passing off action, which normally this is the term we use for in case where you don't have a registration. In passing off action, you have to establish 3 basic requirements. One is reputation, the second is misrepresentation, and that consequential damages. So if you are able to prove all these 3 requirements, in fact, first 2, if you can prove reputation and misrepresentation, third part of damage is assumed, and the court, you don't really have to, in the prima facie case, establish that. It is assumed by the court. So we've also seen examples where there is trans-border reputation. Passing off action can be brought in cases of trans-border reputation. If there is, if you don't have use in India, but there is reputation coming in, you have consumers buying the product, it's in the customs, it's sold, you have advertisements in the flights. There are cases where court have protected the right owner for in trans-border reputation case and under the passing off scenario. And these are also very effective. I would say it's not something that the courts don't, may give it a secondary treatment. Even in a passing off cases, if you are able to prove your prima facie case, you get relief very easily. So technically, when we file an infringement action or a passing off action, the relief which commonly we ask for and we expect from the court is an ex parte order. So these days, because it's a commercial suit, commercial action where there is a loss of money and there's the court, if is able to see there is a prima facie case, there will be loss of, there'll be a greater damage. In these cases, courts are very commonly ordering, if you move an application, an ex parte order. When you say ex parte order, it means that the other side, the defendant, the opposite side, will not be given notice. You get an ex parte injunction order for the time being till the time the other side doesn't enter appearance with an injunction order. This is something, if you're able to establish, and all the lawyers who act for the right owner, when we move the court, we endeavor to get an ex parte order so that we have an interim protection for the client. The second is very important interim order, which is also commonly asked for, and courts invariably, if you are able to establish prima facie case, is civil action, civil raids, civil seizures. So court can also grant, order for and appoint a court receiver or a court commissioner to enter the premises of the defendant, warehouse or stores or retail outlets, and conduct raid and seize the infringing products. The other relief that we get is the final relief, which is a permanent restraint. And the last one is damages, if you're able to prove losses. And costs is something which is also granted. The other second relief, the second basket that I had mentioned, is the criminal remedy. Now, criminal remedy is, again, in these cases, whether you have a registration, if you don't have registration, in both cases, you can actually file a criminal action with the police officer or with the magistrate court, where you can take a warrant for action of, if you want to conduct a raid on the infringing goods. So typically in a criminal remedies, we use this remedy when it's a counterfeit situation. There's like it's an identical product. If it's like a mineral water bottle, it's identical. These are fake goods. We tend to take criminal action, or you don't know much about the whereabouts of an entity. Criminal action is the best remedy we use. In these cases, you just have to file a complaint, prove your case, the prima facie case, and a police officer has the powers. It's a cognizable action, so the police officer has the power to enter premises if he's satisfied that there are fake goods being sold. He can conduct raid, seize the goods, and arrest the accused who is manufacturing or selling these goods. In these cases, typically the equipments used for manufacturing of these counterfeit products, the dyes, the packaging material, everything is seized. And then once a complaint is, though earlier it used to be, it was not easy to get bail, but now because the courts have clarified these are bailable offenses, the accused can get a bail by the end of the day and he can be released, but the trial starts after that. The third bucket is the civil and criminal is typically obviously is used when the goods are within the country. It's inside the jurisdiction of India completely. Now the custom enforcement, border enforcement measures, we use, there is a provision whereby you can register your mark with the customs. So the customs provision helps in import, restraining import of your unauthorized goods. So you can register your mark. For this one, the requirement is the mark has to be registered. If it's not registered, you can't register with the customs, and you need to show that you are the proprietor. So how do you show it? By registration. So for here, you need to have a registration. And if you register yourself with the custom, it's an online provision. You register yourself. All the imports, if you have not listed your authorized importers, will be stalled, and you will be informed about any import of your, the counterfeit or unauthorized goods coming across India. This provision is available only for imports and not for exports. Now the last bucket where we talk about administrative remedies is typically if you have a registered mark, you have a domain name related issues, or you have company name related issues, or if your goods are sold on an e-commerce platform. So if you have a domain name, if somebody has copied an identical, sorry, Kamal, I'll be using again Gillette. If there is somebody is attempting to use Gillette.in, which is not authorized by, it's not P&G's domain name, you can file a complaint with NICSI. NICSI provision, again, is an administrative provision. It is arbitration which is involved. Its INDRP provision is identical to UNDRP provisions. There is no difference between how it is handled. INDRP and UNDRP is almost identical. It's just that the arbitrator is in India. And it's a very effective platform. There is a strict timeline which is followed, and these matters get resolved if you're able to establish through documentary evidence that you are the proprietor of of the mark which is used in the domain, and a solution is, you can cancel the domain name or also have the domain name transferred to your name. If your registered mark is used as a company name, then again there is a provision which is available under the Companies Act. You can file a complaint with the regional director under the company's provision, and whereby you can establish that you're a registered proprietor of that name, which is a part of the company name. And again, this is again a very quick, solution. You can also use a civil route, but if this is available to us for 3 years from the date of the other party has applied for the mark. So there is a limitation time. So if a company has registered the mark, and within 3 years, you can actually use this provision, and it's very cost effective and also speedy. If it is more than 3 years and you've just come to know, then we use the civil route. That is, we file the civil action in the court, maybe district court or the high court, depending on which jurisdiction you fall in. The last provision is if counterfeits are being sold online. We do have the IT provision also. There is provision under that where intermediaries have to abide by the requirement. It's an international standard requirement where intermediaries also have, if there is a complaint from the right owner to intermediaries within 36 hours from receiving of the complaint, they have to stop and pull down the listing of the counterfeit goods online. And it is very effective. The courts in India have really, if intermediaries don't listen to these complaints and there is delay beyond 36 hours to pull down the counterfeit listed, the court really goes very strong against them, and there are actions being taken against intermediaries who don't listen and they don't pull down. So it's a very effective platform. You just have to write to the intermediaries portal, where there is, there's always a link where it is provided where you can file your complaints, and the actions are taken. As an effective tool. So this covers all the procedures and remedies, and I'm happy to take any questions if you have for India. I think that lady has.
Hi, Priya.
Hi.
I have a question. When you said that non-registered trademarks can file a complaint, do they have to file a trademark in order to be a party?
In cases of civil actions, you're saying? Yes.
No, civil and administrative.
So for so I'll answer the civil action first. In the civil action, you don't have to have even a pending application.
No, but you can file it after presenting.
Yes, you
the
can.
complaint.
There's no restriction on
Okay.
when
but
and
it's
when
not mandatory.
Yeah, it is not.
Okay, thank you.
But in case of domain name, the administrative remedies, domain name and company name, the requirement of registration is there, because what is the prima facie document that is available? It's advisable. And in case you don't have a registration, it is blatant infringement. In case of domain name, we've seen cases where we were able to convince the arbitrator. In case of company name, the statute requires that you have a registration.
Okay.
So places where the statute requires that you have a registration, then you need a registration. In case you don't have a registration if it is a violation of the company name, then we would recommend not to use the regional director under the company's provision. We'll recommend you go to civil court, because it's easier to convince a judge.
Okay, thank you.
Thank you so much, Priya. Now I request Kamal to take up the stage and share his thoughts and insights on the strategy of PNG.
Thank you, Azam. And thank you, Priya, for a detailed study on IP enforcement in India. It's working, yeah, I think, definitely. It's not working, fine, okay. So, ladies and gentlemen, we have heard about IP enforcement in India. Now, a little perspective from a right holder on the challenges around brand protection and security challenges, right? So, primarily when we think about brand protection, the other word which comes to mind is counterfeiting, right? Counterfeits in the market. What is counterfeiting? Now, it's been defined in different, I would say, I'm responsible for IMEA, so it's defined in different ways. In some countries, it's called counterfeiting, it's like a fake reproduction, etc. Many countries actually, including India, also include deceptively similar marks as well. To name a few countries, India, Pakistan definitely includes that. But when we think about counterfeiting, what it is, when I talk about FMCG products, it is consumer fraud, plain and simple, period. Why? Because I can assure you no consumer globally would buy an FMCG product. So, for example, what we sell, shampoos, right, cosmetics, etc., or probably a Gillette razor, since Priya mentioned Gillette a couple of times, knowingly. I would like to actually ask all of you, would any one of you buy a FMCG product knowingly that it's a counterfeit, even if it's coming for free? Right, that's the guess. But still counterfeits are being sold in the market, consumers end up buying it. And that is why I said it is a consumer fraud, plain and simple. Of course, there are other things which are related to counterfeiting, like it erodes the brand confidence, it increases the cost for the company in employing people like me who have to fight counterfeiting. Product quality of counterfeits is not as per the standards, right? And there have been many cases globally where they have caused harm to the health of the consumer. They, of course, evade taxes and duties and cause loss to the governments. And also, today, there have been a couple of examples where counterfeiting has been linked to funding nefarious activities, including terrorism and organized crime. Now, well, as a matter of fact, counterfeiting industry is continuously evolving. I still remember when I started my career, the most in thing at that time probably was putting a hologram on packaging to make it secure. Today, I mean, they're probably something which was in the dinosaur's age. Today, a lot of more covert and overt features are required on the packaging, etc. And at PNG, we consider three trends which are actually, as of now, which really needs focus. Number one is definitely evolution of online counterfeits, online business and related online counterfeits. Especially if I talk about the IMEA region, online, it is still picking up on online and e-commerce business platforms. Second is the technology, as I mentioned, about covert and overt features. And lastly, about the types of criminals who deal in counterfeits. Now, from my experience, I can just say there are two types of criminals. And as I would say again, criminals, emphasis applied on that. Reason being, these guys who deal in counterfeits are no different than any other criminal who probably commits a crime for money. They are knowingly selling fake products which will cause harm to the consumer to make money. So one of the concerns as a brand is, I would say with a lot of legislations that it is, and as Priya mentioned, it is considered more like a financial crime, not crime, a financial issue with the company or infringement of companies' rights, where actually it should be looked more as a crime. There are centralized syndicates who deal into counterfeits today with very sophisticated supply chains, either within the country or starting from a country like China, perhaps from India for medicines, etc. And then fragmented units like set alone, which we see a lot in, I would say, Middle East region, where there are multiple different offenders who have their own setup and dealing in counterfeits. And definitely they also have, I would say, different sophisticated ways of entering the supply chain to infuse counterfeits for consumers. What does a brand protection council does at P&G typically? Primarily IP protection, so enforcement, etc. Second is peer collaboration. So we collaborate a lot with our peers in terms of what to secure, where to secure. Also collaboration amongst peers from different corporates through different forums like TraceIt, supply chain integrity, customer engagement. So while we sell our products to Amazon or Amazon sells it through our distributor, etc., but we also do engagement in terms of what more they need to do to ensure that the supply chain is safe and secure. Government relations, well, P&G also has a government relations team which support us a lot, and we do a bit from our side. Investigation and enforcement, online vigilance, and lastly, technology and packaging. See, when it comes to the fight against counterfeits, I think the work starts from your home. So first thing you need to do is make sure your own supply chain, the integrity in your supply chain is absolutely perfect. You need to check your distribution channels that there is no leakage of your packaging or material anywhere. And once that is done, then you have to look forward in terms of training your distributors and managing the whole business. You need to create a channel. So for example, one thing which we do is all our distributors across, I would say, globe are very well trained along with their sales team, merchandisers, etc., on how to identify P&G counterfeit. And we have a very nice system, I would say swift system, for them to report it back to us so that we can, without any loss of time, we have the intelligence with us and we can act upon it. So broadly, monitor and measure, first thing. That is what we do through our agencies, through our distributors, through our channel partners. Then we definitely prevent it by making our products more difficult to be copied and eliminating them by conducting enforcement. It's a bit repetitive because I'm just going to come to my overall P&G strategy of dealing with the counterfeits. Covered that, so I'm just... So primarily at P&G, our strategy is 3 pillars based. First is attack and frustrate counterfeiters. Second is enable and engage third parties. And third part is to build a world-class R&D. To get into a bit of details of this. So when it comes to attack and frustrate, we invest a lot of time, energy, and efforts in monitoring a counterfeit supply chain. We don't believe in just doing a retail or just hitting the manufacturer. So when we are doing any intelligence gathering, we map the whole supply chain of the counterfeit from the retail level to the manufacturer to the ingredients provider. And then collaborate with our peers on what IPs we have, what all we can secure. Just to give you an example, there's a product called Fairy, which is a dishwashing liquid. Now, when we see a counterfeit of Fairy, I'm not saying it is there, but assuming, we will not only look at the product in the market, we will also go behind and see who is actually manufacturing the product. Now, these kind of products which have liquid, they're usually, they're refilling centers. So we'll find out who is refilling it, how that product from refilling channel is coming to the market, plus who is manufacturing or printing the stickers to be put on it, plus who is actually blowing the bottle, who is manufacturing the bottle. We will secure our right because if it's just the bottle, you don't have any IP as such, the trademark is not there on the bottle. So it is very I would say, important to ensure you have a 2D or 3D trademark registration on that bottle design as well, the very component from where the counterfeit begins. And based on that, we would hit the whole supply chain. Engaging and enabling third parties to win against counterfeiters, right? So, as I mentioned first, so enabling and engaging third parties it's a very wide scope. It starts from our business partners, our distributors and wholesalers, our customers, our consumers. Then it goes to the vendors, law firms, investigators, and suppliers. Then intermediaries, like internet platforms, internet companies, platforms to search in internet, for example, Google search, etc., to find out, dig out more and more. Then supply chain management, for example, shipping lines or shipping containers, companies managing shipping containers, as well as in some countries we are trying to collaborate with payment vendors as well. And lastly, the government, definitely, prosecutors. Now, one thing we always need to keep in mind that public prosecutors are not very well trained on IP crime or how to deal with IP issues. So it is always suggested, or as a strategy, what we try to do is we try to provide as much support we can do to them in terms of on IP strategy, in terms of providing them the reports from our labs or at times from private labs, as the case may be, as it may be needed, of the authentication of the product or how the product is counterfeit. Then coordinating with specialized police units. To give you an example, in South Africa, there are multiple different units. At times, it is not possible to do an action through SAPS, which is South African Police Services, because of various reasons. At that time, we use specialized units like K9 unit if it has to be done immediately. So most of the countries have these kind of different options. If we talk about UAE as well, most of the enforcement action is done through the Department of Economic Development, DED, as we call it. But in certain Emirates, you have the alternative to use the police as well. And it depends on the case and the need, because if you do the raid through police, it will go to the court as well. If it's done through DED, it's an administrative action, it'll end with a fine. So you have to be very strategic in terms of, because the investment you'll be making will be different in both cases. So you have to be very strategic in choosing where you are going to collaborate and to what extent. And definitely customs to stop import of counterfeits. Lastly, world-class R&D. I'm very proud to say, actually, P&G holds certain overt and covert patents for certain covert and overt features. We have our own in-house team of 4 to 5 researchers. Why I said 5th is because I think he joined recently. And we have patented technology on machine learning and AI, which we recently got patent in a few countries. And it's all developed in-house. So we invest a lot of time and effort in developing our own technology to provide and print covert and overt features on the packaging. Now, that can be from small, I would say a 2D or 3D QR code to readable QR codes to features in the barcode to a globally synchronized printing system of the batch codes. And my friends, that's how at P&G we deal with the counterfeits and the challenges related to that. That brings me to the end, so thank you. Any questions if you want to ask, please feel free.
I was about to open the floor for the questions. So anyone in the audience has any question?
On the counterfeit front, you see a range of sophistication. Shampoos, for instance, that are completely different versus ones that are virtually identical in formulation.
I've never come across a counterfeit product which is identical to our formulation. right? And so, for example, one of the tests which we do, and we have our own small, lovely kit which we use, which has certain chemical analysis. So we know what active ingredients a counterfeit product would not have. So we test for them on the field, and we know it's a counterfeit. So they're obviously, and always they're different. We have never seen a counterfeit product which is identical in terms of formulation.
So I have this question now. So how do you decide on legal proceeding against counterfeits? Like, if it's a big company or a small company, who is counterfeiting your products. So how do you decide on legal proceedings? So do you have any like specific actions for a big manufacturing setup or a small manufacturing setup? So how do you take the decisions on that?
Well, a criminal is a criminal. It doesn't matter big or small. If it's small, it's going to get big one day, eventually. So, no, we don't discriminate on the kind of action we would take against a manufacturer. However, it may differ for a retailer, because there are cases of innocent retailer as well. And as you said, you read while you were doing my bio, right, that I am a strong advocate of protecting our consumers as well as retailers, right? Because you don't want, we know that they end up having a counterfeit because they want to make more profit. And usually that's how counterfeits enter the supply chain, by offering higher discounts. But they are not very well trained on, I would say, saying that it's a counterfeit. So there we probably go soft by way of, I would say, a slap on the wrist or just an administrative action. But if it's a manufacturer then, or a wholesaler who is knowingly doing it, then definitely we go as in full-blown with criminal enforcement, followed by supporting to prosecution, etc. And again, as I said, it depends on country to country. For example, if I'm doing a raid in Sharjah, which is another emirate in UAE, I will have very less option to go to the police, and most likely it's going to be an administrative action. Whereas if I'm doing it in Dubai, I have more support, or I would say it's easier for me to utilize the police. Or Abu Dhabi, again, it's easier to utilize the police. So I would choose based on that.
Right. So in some cases, the retailers like Amazon, say for example, if somebody is selling your counterfeit product on Amazon, so what kind of cooperation you get from these third parties? I know you collaborate with such parties, but what kind of collaboration or support you get from them? And how do you identify these kind of products which are being sold online, because it is being directly delivered to customer and then you don't know how it is being handled?
Okay, I won't name any platform as such, right? But I would say, since you mentioned Amazon, I would say Amazon is very collaborative, definitely at a lot of places. But how we coordinate with these platforms are by reaching out to their legal teams. We have MOUs with many of them where they have willingly agreed to share data of these counterfeiters with us, through the involvement of either the court or the law enforcement, because definitely they just can't give the data because of different privacy rules, etc. in different countries. Right. So there is a level of coordination on that extent. And then third is, what are investigators are for, right? You order the product, then you trace them back. So
right, makes sense. So if we can see if we have any other question from the audience, yes.
There was a bullet that says honest use can be more effective than registration. Did I understand this correct?
Sorry, you just said what? Honest?
There's honest use is more effective than registration.
Yeah.
What is honest use, and how could it be more effective?
No, so in India, like I said, use is it's superior to registration. So unlike like in the US, where it is, if you have a registration, the first person to have registration has better rights. But in India, if you have use, it is honest use. You are able to establish that your use has been not influenced by another person. Give you an example, maybe that would help. We had there was FedEx case. FedEx had sued one of our clients in India, and it was in relation to FedEx, as we know, it's a courier service, and our clients was into basically stock market services. The services were absolutely different, but they had sued our clients, and it was, while we were preparing the defense, our clients were able to show us that they had adopted FedEx, if not prior to FedEx having changed their mark to FedEx. They were Federal Express earlier, and then to FedEx. If not earlier, it was almost simultaneous. That was a US base, and we were India. So we were able to establish through documentary evidence that when we started use of FedEx, our clients had adopted it because they were ex-employee of the federal bank based in Kerala. So they were like 5 of the bankers who had come together. They were ex-federal bank employees. That's how they had coined that name. It was coincidental that they had honestly adopted, and they had documents to show. They had board meeting, resolution documented, and we were able to establish that we were, if not prior, we are simultaneous. By that time, FedEx had not really had come into India. So this is honest adoption.
Any other question from the audience? Okay, so I have a question regarding this trademark registration in India. So you said that registration of trademark is not mandatory, but what all kind of proofs are required to prove that you are the owner of that trademark? You said, maybe packaging, but what is acceptable in that?
So when we have to establish, first is use and then reputation. So documents regarding how you first launched the mark, the use. It's like old wine. The longer use you are able to show, the longer reputation you're able to show. So documents that we would typically will want from our client to establish use will be invoices. When was the order for, the brand and printing, and what was the decisions, how, internal communication, brochures, pamphlets, which has dates. We will use, documents, which is, these days everything is on internet. When we started domain name registration, when did we get domain name registration, advertisement in magazine, so these are typically a good use document that we want from our clients when we have to show reputation.
Right. So, Kamal, I have a question regarding these third-party engagement, wherein you said you collaborate with them, and there is some third party which is kind of a payments enabler. So, how does that thing work? Because payment is something which is a distant from you, and then you have to find the information in that. How does that work?
Well, I would say it's a multi-party engagement, because, for example, you bought something from Amazon, and the payment platform is engaged with Amazon, but perhaps we may have better terms with them. So it's a multi-party engagement where we discuss what can be done to safeguard the consumer at the end. And one of those ways is to, take back the payment.
Okay. Great. So any other question from the audience? Okay, so I have another question for you, Priya. So, we talked about the Commercial Courts Act when you said that these courts are kind of fast-track courts now, but we have seen that there are a lot of backlogs in India. It takes a lot of time. So I'm wondering how fast these courts are, though they are fast track. How long does it take to, complete this whole case in courts, in these kind of courts?
So as per the Act, the requirement is that you have to conclude it by 3 years' time from the filing. So it's like there is a case management provision under, and it's strict timelines. There is strict timelines by which the pleadings have to be completed. So now, typically, because of the fast track, the newer matters. First, I'll deal with the fresh new matters. Because these are IP savvy judges who are familiar with the IP laws. They are seasoned to handle the IP cases. So they're not reluctant to pass good orders. And if there is violation, they do, they can come forward. So we see within 3 years, after post-trial, if the matters go into trial, they get concluded. In IP cases, typically what we've seen is once you get an ex parte order or you get interim injunction order, parties generally in 85% of the cases don't want to go into trial because trial is a time-consuming process, and they go ex parte, they just disappear without entering, they just stop appearing, or they come forward and settle the matter. So yeah, we would see that because the court is very strict, and we see typically within 3 years, if the matter goes into trial. Otherwise, if it's not going to trial within a year's time, we do see solution. The old matters which are pending, they also, are trying to be, the courts are taking steps to fast track it and find a solution in those.
All right, great. One last chance for the audience, if anybody has any question. All right, so I have one more. So this is regarding the remedies in the civil proceedings and the criminal proceedings. So I'm just wondering, what is the difference in the kind of expectations out of the case we proceed with? What's the difference in the remedies expectations in the civil versus criminal courts when we take up this?
So the expectation is in a civil action, the general remedy, you can get damages because you know exactly who are, you've identified the party. The common feature, I would say, between a civil action and a criminal action, there is raids and there will be, you do seize the goods, which is infringing your rights. The difference between a criminal and a civil is you get better damages in a civil action vis-a-vis a criminal action. In a criminal action, the advantage is the accused has the fear of going to jail. He is arrested and there is a criminal, he has the fear that he will eventually, if we are able to, prosecutors are able to prove their case, he or she will go to jail.
So Kamal, how do you decide that?
I was about to answer that. Couple of things. As Priya mentioned, damages. So, Priya, remind me, how many cases do we get damages in India?
Yeah, that's right. That's post-trial.
So, and civil proceedings tend to be longer, more expensive. Criminal proceedings are, I personally prefer criminal proceedings in most of the cases, except when it's a look-alike case. As I said, while the Trademarks Act covers it under falsification of trademarks in India, police is not very willing to cooperate whenever it's a look-alike mark. So at that time, you tend to go for civil action, or you tend to go for civil action when the other side may have filed an application for registration of a trademark, maybe identical for a counterfeit. But in that case, it's better to reach out to a civil court rather than going for a criminal enforcement, because you're dealing with police officers who are not savvy with IP, the intricacies of IP law. It's easier to convince a court to take an action on that rather than dealing with the police. And other risks involved in dealing with police and having elaborate discussion with them, on compliance issues, etc., corruption, etc., etc. In many countries, you face those problems. So it's again a call on case-to-case basis, I would say. There's no set formula, but set formula, it's a straightforward case. Yeah, I would go ahead and do a criminal enforcement, where I know police would act on it, simply on the basis of a complaint. If there is something more involved into it, then I would prefer a civil case. But damages is never the criteria.
I would like to add something because, like I said, settlement happens. So yes, in these cases, when we say that, okay, if we take you to trial, you will end up paying this much. So when we are discussing and negotiating a settlement with the other party, they tend to pay us some costs, and we are able to at least recover the expenses.
Oh, you finally said some recovery as well.
So, yeah.
Great. All right. So I guess if there are more questions, we can take those questions in the networking session, which will be in the lunch time. Now we'll hand over the mementos as a token of appreciation of your help. Well, thank you so much, our panelists and the audience. We'll start our next session in 7 minutes from now. You can have coffee by the time. Thank you. Welcome back, everyone. We're now starting our session 3, the IP challenges in future of IoT, that is Internet of Things. I'll be moderating this session, and I'll introduce our speakers. The speakers are Gil Pelberg, the Intellectual Property Manager, Camtech Limited, Israel. The Gil Pelberg is the IP Manager with Camtech Limited, is an IP Development Executive, focusing on the creation of high-value portfolios. Give a round of applause for Gil. Thank you.
Thank you.
So based on more than 25 years of senior R&D and product management experience, Gil specializes in aligning intellectual property protection with a company's business objectives. His previous positions include Vice President of IP at Shell Case Limited, a semiconductor IP company, a Chief Operating Officer at Hybrid Razor Limited, a consumer product company, and Vice President of Product Development and Engineering at TraceGuard Inc., a homeland security company. Gil is also an innovation facilitator. He facilitated innovation sessions at local and international companies specializing in IP generation and new product development. He is a co-author of provisional patent applications, use and abuse, and is a named inventor on 28 US patents. A graduate of the Technion Israel in mechanical engineering, Gil holds MSc degrees in mechanical and electrical engineering from Drexel University and MBA from New York University. Now, our second speaker is Issam Abdul Khalik. He's a senior legal consultant at United Trademark and Patent Services. Give it a round of applause for Issam as well. So Issam Abdul Khalik is a senior legal consultant with over 23 years of experience in litigation, brand enforcement, dispute settlement, portfolio management, opposition, and rectification relating to trademark, patents, copyright, and other IP cases in GCC, Middle Eastern, and North African region on behalf of firms Fortune 500 and domestic clients. He's a member of the leading IP associations, trainer, coordinator, and speaker at conferences, seminars, and webinars in the region. Now, I invite Gil Pelberg to start with his presentation, and he'll take over from here. Thank you.
Thank you. Thank you very much. So again, my name is Gil Perlberg from Comtech. And Comtech is a manufacturer of semiconductor inspection equipment. And we deal with a range of technologies. It's a very integrative, multidisciplinary kind of a product. And as IP manager, I'm often asked to look into new domains that I'm not an expert in, or that none of us are experts in. Can you hear me with this? And my go-to is usually to do a patent landscape and understand what's happening via patents. I find that patents are a great database. People who patent invest money to protect something they think they will need in the future, and they describe what they do. So if we can understand their patents, maybe we know a lot about it. And the patent database, the metadata, is very simple to understand. It's consistent. It's very deep. People don't usually appreciate how much you can get out of it. And using the right tools, we can do an analysis. So when I started looking into this, what is the IoT patent domain? What does it mean? The IoT space is very fast-moving. There is endless number of participants, many small. The technology is by definition very integrative. So there's a lot of questions about it that I wanted to do. And I'm going to show you a first level IP landscape that I do. And it will tell us a little bit about the IoT space and a little bit about patent landscapes, at least the way I use it. And as the first level, what I do is I like to know who's playing there, when did they start, or what are they doing, where, what countries. I like to do a quantitative analysis, but also try to get a sense of the quality of the patents we're talking about. And then to identify opportunities and risks. So that's what I'll be doing. And there's many more layers you can go into with the landscape analysis to get insight for your business. The first thing I did was very simple. I just typed in IoT and Internet of Things, and I get 58,000 patents. Now, the idea in a patent landscape is to build a meaningful portfolio that you want to analyze. That's the first step. If you're not dealing with a meaningful portfolio, the rest of the analysis is kind of useless. So this was the first thing I did. The second thing I looked was for the CPC. Now, there is a classification for IoT. It yielded only 10,000 patents, and I looked into it a little bit. The classification was added 2 years ago. So the classifications are updating all the time with technology updates, and it doesn't really reflect all of what I think might be the IoT. So using what everybody does today, ChatGPT, what kind of CPCs are used in IoT patents? I got a list of CPCs. And again, this is the first glance at this landscape, so it will suffice. And I looked at these CPCs, and there's close to 500,000 patents in this domain now. That's a good start for a very big overlook, 30,000-foot overlook into this domain. And the first thing I do is I look for who are the big hitters, and when did this industry start? So first of all, you'll notice that it's a very relevant late industry. 2015, things started to happen. There's a handful, or not a handful, but a few very large players. But I can share with you that there's thousands of players. Not surprising, 500,000 patents. But I often look first at the big ones. And this is based on the keyword and the IoT and using the keyword analysis. This is based on the CPC analysis. It's different. I'll go back. Here we have Samsung on the top, and State Grid, and Vision Vera at the top. If we use the CPC, we have Huawei, Samsung, ZTE, other companies. I personally trust the CPC. People who do classification of patents are experts at their job. They don't just do keywords. and somebody is doing the job for us, and they're doing it because they need to do it. We're just piggyback on their work. So I used their efforts to try to get a better sense of where I am. So I took the CPC analysis going forward, not the keywords. And this is also a lesson for me because many times I start with keywords. It's fast, it's intuitive. It's not right, often. So it's partially right. So I use the data that other people provide. But the second thing is what I've showed you up to now is based on size, number of patents. And size counts, but it might lead to wrong conclusions. This is another view of the same data, of the CPC 500,000 patents. And what I'm using here is quality indicators of patent site. Patent site of LexisNexis has some quality indicators. This one is external citations. How many times the patent was cited? And the thinking is that like academic papers, if a paper is cited a lot, it's probably interesting. A lot of people recognize its importance to the industry. If a patent is cited a lot, there's probably a lot of material in it that's relevant to other patents. The people citing, the criteria that I use are examiners. If we look at all citations, we might fall into self-citations, and there are people who say that they can manipulate citation count. So I exclude all of those, and these are examiner citations. And my thinking is, examiners don't really have a point of view on this. They were doing the work. They're citing work patents they think are relevant. So now we see on the y-axis the citation analysis, and on the x-axis the portfolio size. And it's not the bigger that wins always. You see that, how do you pronounce this? Y? And ZTE have the largest portfolios, and the tracking line shows the progression over time. You can see that ZTE had a bigger portfolio and is reducing it. Might be an interesting fact that you might want to know. Microsoft started strong, but its patents are not cited as much as they were in the past. And Qualcomm is growing in size and citations, which can be interpreted as technology relevance. People are looking at Qualcomm patents more than they are at other people's patents. At least the examiners are. So there's the quantitative analysis based on numbers, and we can get into deeper levels based on citations. Now, another way to use the citation analysis is I throw a portfolio of the top 1,000 patents in this space and the top by citation analysis. So my y-axis is again the citation analysis, and the patents we see in the graph are all the ones that are at the top of citation analysis from the 500,000. And there's a handful that stand out to be cited a lot. If I have to study this domain through patents, I can start looking through the 500,000, or I can start looking at the ones the examiners found were most interesting. They did the work for me. So I tell the story sort of. I was once on a safari in Africa, and I got in the Jeep with the guide, and I started looking for animals. And he sort of laughed at me, and he said, "You don't look for animals at this stage. You look for other Jeeps. Where you see the other Jeeps is where they're looking at animals." The examiners who are citing are giving me a hint where there's interesting stuff. So now I know to look at these patents, and I looked at that one in specific. And I know you can't see a whole lot, but I'll point out two facts. One, this is a strong force intellectual capital. I don't know if the name means something to most of you, but the word intellectual venture means something to most people here. They're friends. They're friends. And if I look at the patent, there's something interesting in this patent. It's not a patent, it's a book. And it's cited a lot because there's a lot of content in it. And there's a lot of content, meaning they claim one set of claims, and then they start a string of continuations that's never ending. Now, I'll come to this again at the end. When I'm looking at this domain, I want to find what the size is. I also want to find opportunities and risks. There's always risks, but any risk concerning a troll is higher level risk for me. Similarly, I did a similar analysis, and what I want to find here is what I call mavericks, people who are going to be something soon big. If you look at the x-axis, it's in years since publication. Point 1 is a month and a half, or a month, point 2. So most of these are not yet cited often because they're just come around. They've just been published. But there's a big patent there that after 2 months, examiners are citing it. That's an interesting fact. I'll give you a hint. It belongs to the same family as the previous one. So they're active in patenting, and I would encourage my company to be aware of this fact and not take risks with them. Another thing that I use the patent landscape is to see IoT spans endless amount of industry. It's just a buzzword for a lot of things. So the patent landscape allows me to identify which industries it's used in. So these 500,000 patents fall into authentication businesses or products, into server products, packet transfer, gateways, and then you can grow this radar chart with more and more layers. And you can dissect it even further to subdomains. So most companies don't hold the whole space, but they can identify their subdomain, see its relevant importance and size in the big picture, and then go deeper. Now, we talked about also the where. We talk about where patents are enforced. It's also interesting to note where they were invented in. Where are the R&D centers that develop most IoT products? That could mean a lot to business. And you see that a lot of it's in China, and second in the US. And then there's a large group that because of the scale of the graph, we don't really see it. So I can take another look into this, and I've kept China and the US out of this analysis right now, out of this graph, so I get a much better resolution. And you see active in South Korea, Germany, and the EPO. This is active. This is where patents are filed. But at the same glance, let's look at where they were invented. South Korea invents a large chunk of patents and files them elsewhere, apparently, because South Korea on the other graph is much smaller. Japan invents a lot more than Germany, but over here it's not reflected. The EPO sort of distorts this picture. But you can see players that invent and don't protect, etc., and the opposite. This is where I get to the most business interesting after I've seen the big picture, and I want to make real business headway. The patent landscape allows me to dissect what type of owners hold these patents. Are they corporates, academic, individual investors, or NPs? And that can mean a lot of things for people doing business. If I look for opportunities to buy or license or do some collaboration that's business-wise will be simple, it might be inventors. Single inventors usually have less of a mechanism, bureaucracy to do business, and might have a bigger motivation to do business. I look at the NPs because I want to understand the risks. Now, in this graph of 500,000 patents, the NPs are the lowest, but there's thousands of patents that these NPs hold. So I want to take a deeper dive into the NP world. And they started stronger a few years ago and a bit declining. And when I look at them even deeper, I can identify which companies are involved. Intellectual Ventures is number 3 here, the green on the right. I'm not sure it's the same ventures that was before, but it could be. I didn't go into that deep of a dive. So this is a first glance at the IoT landscape that helped me understand what is the space, who's involved, and what are we talking about to make the discussion more grounded. Thank you. Questions?
So if we do not have any questions right now, maybe we can park them towards the end of these presentation. Now, I request Isam to take this stage and then discuss more about the IoT.
Good afternoon. My name is Isam. I am a lawyer who are in the field of the intellectual property since 23 years in the UAE. We are welcome all of you here today. Today our topic is about the IP challenges and future of the IoT. And we don't want to repeat what is the IP, like intellectual property rights, and we don't want to repeat what is the IoT, like Internet of Things. But we were talking about the overlap and the intervene between these two fields together, actually. So first of all, we have to understand that the intellectual property, like trademarks, patents, designs, and so it's all like same like assets. Like if we are owner of a home or a car or something, it should be protected. So once we will have a home, we have to keep a fence inside this home in order to protect it from any robbery or something like that. IoT is like in our life right now. We cannot get rid of it. Same, it's in our mobiles and our computers. Now about 80 billion devices are linked to the internet right now around the world, either from airplanes, cars, and mobiles. So, and somehow there should be some intervene between the IoT. It is intentionally or unintentionally with the copyright, or with the trademarks, or with the patents as well. So, for example, if we are talking about the telephone, which we are using in our hands to check the heartbeat while we are, jogging or running like that. This actually, we are talking about if we are keeping this information for us, so it's fine because it will give us the heartbeat and blood pressure, like why we. But if this one is linked with some medical provider, like the hospital, we are talking now about the privacy law, actually, whether it can be leaked to another companies, like insurance companies or something like that. So it can affect your insurance policy in the future. Maybe they will give the premium higher like that. So somehow it will give some information about you. Same like car accidents, same like also you're driving. Let's say, Mathalan, you are driving in a high speed. Okay, you have a sport car on a high speed. This it should be private for you, otherwise you can take fine. But let's say this car is linked with with some company who are these companies are transferring the data to insurance companies. Then the premium will be also higher, like that. So Internet of Things, it does not mean that only, it is, obviously it will ease our life, like, making the washing machine working, or we can make the heater working, or the AC or something. This is the simple things, actually. But obviously in the military things, it will be used in a more sophisticated things, actually. When we are talking, as Jill said, like that, about the patents, like that, also it can be also intervening with some patents, and somehow, because when we are talking about Apple, Samsung right now, there is something called patent trolls, actually, where you can, some companies or some people, they will buy a patent application from a bankrupt company, which is about to close. So he will buy this patent, and then he will start to sue big companies for this idea, where there is nothing actually, but just to gain some money. This is actually so many fields we can talk about IP, how to use it in a correct way, how to use it in a bad way, actually. So, but we are talking about, in general, if we are talking about the IP, how we can protect the IP rights when we are talking about IoT, which is a very open world, actually. So if we come with them, for example, for software patenting, when we are talking about IoT, okay, this is a command. It is issued from, for example, from your mobile to make the washing machine work in your home. Okay, how many software you are using right now? The software of the washing machine, the internet of the provider. You are using your also software from your mobile like that. Whether the provider has allowed us to use this software or not, whether it is this software are copyrighted or not. So we have to check these things, and it should be done like a deep study about how to protect the IP rights while talking about IoT, because IoT, it is like air right now. So it's coming in every building, in every home, in the street, in every car like that. We cannot stop it. It is like the internet, we can say. So how to protect the people from that? Why we want to protect? Because, we have to continue encourage the inventors to invent more things, actually. Otherwise, if your idea will be taken easily, no one will invent later on. So everybody will just stop and will say, just no need, because I'm not protected. So we have to continue on protecting this. Now, the laws in the UAE and legislation in general are very developed and well established. We have judges, actually, who are specialized in the intellectual property protection. Also, we have some experts in the courts who can really understand what is the difference and what are the limits between the IP protection rights and what is the IoT and the freedom of using the internet, actually, in general. So for software, this was an example only. If we are talking about copyrights, for example, we are talking about copyrights also. It can be like for lectures, for songs, for plays, so when we are talking about IoT also, we are talking about internet again. So how we can protect this one? So we suggest that there should be some more conferences and more summits, actually, and more events to talk deeply from the experienced people about how to protect the IP. IP is protected by the local agencies or local authorities in every country. But when we're talking about something which is new and coming so fast in every field, actually, so we have to talk deeply about this matter in details, actually. Also, when we are talking about why we should protect more, because it will reduce the litigation in the courts, actually. So every big company like Apple, Samsung, and other companies as well, they are obviously spending a lot of, it can reach up to billions of dollars, actually, to protect their copyrights. So we are talking about patents, we are talking about trademarks, we are talking about copyrights. Everybody knows, like, if we will take, for example, one Apple phone, Apple is protected as a trademark, the Apple itself. The design of the iPhone is protected as a copyright, as a design, industrial design. And the software itself, how it is like a copyright. So we are talking about three things in the same device, actually. But we did not talk about the IoT, how it can intervene in these three things, how we can protect ourselves, how we can protect these big companies from this infringement, let's say, that somebody can use it in a bad way, actually. Also, we are talking about trademarks, IoT also. When we are talking about trademarks, it should be protected properly because, trademarks is in everywhere right now. It's in the shopping malls, it's in the product. It can be also on a service, actually. Services can be provided like by big restaurants, by legal services, by like that. So it should be protected as well. And also, we are saying about the most important is the data privacy, where we are talking about IoT. It can transfer a lot of data, where it should be also protected and should be under the permission of the sender, actually, whether it can be used against him in the future or should not be used against him. So this is in general, we are talking, this is the challenges which will be. And as we said, like, the laws here in the UAE are really specialized and good, and it can help for future dispute or litigation. Courts are ready to handle all such type of things. And just we suggest like it can be more events like to study these matters deeply because it's a new thing actually, and by year it will be more developed. So this is what we suggest right now and recommend. Thank you so much. And if there is any questions, we are ready. Thank you. Thank you.
So anybody in the audience has any question?
Yeah, sure.
Hello. Okay, I have a question for Mr. Persberg at first. Because all the graphics that you have shown, they look to me graphics made using PATStat from the EPO. Is this my impression correct? Or in case you are using your own software and tools, this can be accessed for free or bought by Camtech? Not the data, the tools.
Yeah, the tool is from patent site, what they've shown here.
Yes,
And,
they are made with the PATStat.
Patent site works with LexisNexis, and it's a paid license,
Yeah.
et cetera, et cetera. The key that I found, there are other tools around. Some are very, very accessible. The problem that I've had is that the data is not always robust. And I can share with you a personal experience that I'm having right now with the company that I'm here with, Camtech, on a
Yes.
certain patent in Japan that we filed. The associate there spelled Camtech with a K. Now I'm doing a patent analysis, and I'm getting patents from Camtech with a K, and there is a company called Camtech with a K. You have to clean the data. If you don't clean the data, you're garbage in, garbage out.
But I can use the tools that you provide to make my own analysis on patents or not?
You would have to work through patent site or to find access. It's not, you have to get a license.
Okay, thank you.
I can talk to you later about this if you want.
Okay, thank you very much.
Thank you.
Yes, any other questions? So by the way, I can also help you with that access to that total patent. I guess you're using from the LexisNexis?
LexisNexis has a few products.
Yeah, okay.
This one is patent site.
Okay.
It's not total patent one.
Oh, okay. All right, so anybody else, any other question right now?
Thank you for your presentation. My question is for you both. Actually, if IoT software is based on open source, how these open source codes can be protected under copyright law? And the second one, IoT, throughout the IoT system, actually anybody can be reached, and by hacking this IoT system can be reached, for example, the IP rights of the other machines?
Actually, for protecting the softwares, actually, in general, we are talking about some authorities who has to check the software, whether it is coming from open source or it should be by developer, like that. So once it is protected by a copyright, actually, then we have to check the dispute. If there is any, we cannot just complain to the authorities like that. No authority will move just because of any hacking or something. Just they will say, okay, this to go to the court. The court will appoint an expert in the IT and in the copyright sometimes. So they will check whether it is an open source or not. If it is an open source, so it is the developer himself, he kept it as open source, no more protection can be like that. But if it is like, it is for the developer and it's locked for him and he is using like for banking systems like that, whatever. So we are talking about hacking, it can be a crime also, not only by the copyright law. So in case that, it depends on the case and what is the damage will be based on the hacking which will be done. So based on the result actually, then they will take the action like that. Yes.
I'll just add, I'm not an expert on the legal sides, but I do know that open source is not free for all. There's a lot of legal issues of ownership. And the legal side of going to court is one aspect. The other aspect is due diligence. If you're under due diligence and you've used a lot of open source You need to show that you know how to use it and that you're using it right. That sort of addresses some of what you were saying. So it might not get to the courts, but somebody will evaluate and see how much it's worth.
Mr. Perlberg, thank you for your presentation, which was quite interesting for me, since I've always heard about patent landscape, but in fact never seen the demonstration. Now, going further, you told us that it is the first level. Okay, you start more or less with 500,000 patents. You showed us that in the end you may have a few thousand NPEs patent. Isn't that too much information? What can you really make with that for your company? So you showed us the CPC and helping you to reach a number of 440,000 patents. Wouldn't it be better if you try to reduce the number of classes or subclasses that you are using to reach, I don't know, maybe, or to start, I don't know, maybe from 10,000 patents or 15,000 patents to have something useful? Because when I see that, I mean, okay, it's lots of information, but it's TMI for me. It's too much information, or the only, let's say, advice you can give if you just take that is don't do anything. It can be dangerous.
Yeah, I just showed you a first level because it's the first time I'm looking at this domain and want to talk about something in it more than just a casual conversation. So I try to put boundaries on it. Of course, we go much deeper and very fast. And we use keywords as well, and CPCs and other patents, similar patents, to reduce it to a manageable number. It is based on the question you want to ask. With Comtech, I know the domain of my competitors. It's not large. And I study that domain in depth continuously, usually for changes in it, what's happening. I sometimes like to look for mavericks. Who's in this space starting to patent and getting a lot of examinations? So there's a few things you can do with the tool. I showed you a very broad brush how I start, and then through a discussion with the business people, what's of interest to us? We do a deep dive, and we create alerts that will pop up automatically. We don't have to sit in front of the screen all day long. So I think my understanding is that it's another tool. It's a huge database. It's a reliable database. You should try to make use of it. That's the promise.
So yes, together with the IIPLA, I also run a IP analytics and search company. So I do these kind of landscape, and then I normally keep these numbers from 2,000 to 15,000 so that it's manageable and it can be manually reviewed as well. So at times, we create the taxonomy and categorize them manually instead of CPC classes as well. Yeah. So I have a question related to that again. So you said that you can create more and more layers in that circle you've been showing, right? So was that specifically based upon the CPC classes only, or you created that maybe by the manual taxonomy? At times we get the taxonomy approved by the client, and then we then categorize it. So I was wondering how it was done.
So in my what I like to do is have a process and continuous dialogue. It's not a one-time shot, because that holds little value in my mind. There's a lot of learnings talking with the customer. In case of my company, it's my management, and a constant dialogue. They'll ask more questions, more clarifications. They'll bring information from the field. We found something here, we do something this, and I don't have to start at the top always. I already done a lot of the base work, and I just have to fine-tune things. and we're familiar with a lot of the past art. So we only have to go to the differences. It's a different discussion than doing a one-time project with somebody who's less familiar with the tool.
All right, so we are starting with our session, fourth of the day. Trademark is querying, protecting trademark across borders. And the speakers for these sessions are Henrietta Newton-Martin, Legal Manager, United Nations, UAE, and Richard Milchoir, Associate Lawyer and Partner, Herald, France, Sergei Medvedev, I'm sorry about that, Partner, Head of Legal, Gorozhsky and Partners, Russia, Elizabeth Kirioni, the Kirioni Trademark Detective Bureau, Russia. So I'll introduce Henrietta so that you can start with that. So common law qualified lawyer with years of experience in practicing law in UAE, Oman, MEA, and India, specializing in cross-border litigation and legal advisory, serving as an in-house counsel for legal matters, ability to render strategic advice on company policy, HR policy, CSR, producers, contracts, and legal documents spanning across areas such as litigation, dispute resolution, and arbitration, airports and aviation law, construction, PPE, IT, corporate and commercial laws, international laws. Possesses core competencies in building key alliances and partnerships with the stakeholders, ministries, and government entities. Experienced in handling cross-border litigation and cross-border disputes, industry expertise expands academia, government projects, aviation, PPP, food industry, IT, hospitality, production, and manufacturing sectors. I think it's a long list. So here is Henrietta, and she'll take care from here. Thank you.
Well, greetings, everyone. I'll try my best not to make it soporific. As it is, you'll have come back from a lunch break. So I understand that, even I have. So I'll try to keep it succinct as well. Well, I think the first thing is to get acquainted to the podium. Well, as you can see on your screen, our topic for discussion for this particular slot is trademark squatting and cross-border protection. This is Henrietta Newton-Martin, as he, at length, introduced me, senior legal counsel and faculty member. I'd like to begin with an interesting quote by Blaise Pascal, just to begin it, on a lighter note. Blaise Pascal is one of my favorite philosophers, of course, and he's said to have remarked once, "What a chimera then is man! What a monster! What a novelty! What a chaos! What a subject of contradiction! What a prodigy!" He says again, "A feeble worm and both, the pride and the refuse of the universe." And to that, I would like to add and ask, what is law if there is no impact? And what is law if it does not meet its purpose? Well, you will see a colorful slide that is going to be vibrant and just wake us up. I've seen throughout the sessions like it has been monochromatic or something in beautiful colors, light colors, but I've kept it deliberately, colorful, because I like the world of colors. Well, and to be precise, in fact, just to draw your attention towards key points. Well, so what is law again if it does not meet its purpose is my question. And over the years, what has been done in trademark squatting, if I may ask? I'm sure it may not flabbergast some of you when I say that in recent years, trademark disputes have become a subject for corporate war, with corporate giants battling their way out of trademark misuse and abuse. And of late, there is this trademark squatting, which has raised its ugly head over the years. So you have a number of legislations in different laws, domestic legislations, and we have, of course, our WIPO, WIPO treaties and conventions. I'm here among eminent IP lawyers and counsels. If I may ask them, just to recall, so that probably during the end of the session we can have the question and answer round, and maybe from there we could take it vibrantly. But I have a question. Have you read the WIPO 26 treaties and conventions meticulously? I have done it. Okay? And I want to know, are you satisfied as legal counsels, in-house counsels, specializing in IP, whether it addresses trademark squatting? Of course, you might say trademark abuse, it's well covered. Trademark misuse, yes. Trademark infringement, yes. But trademark squatting, you might say, what is the difference? I'll explain to you. So let's keep this at the back of our mind and then proceed with our slides. Let me begin with the Apple story, just to set the perspective. Of course, again, all trademark lawyers will know the citation very well. That is RXD Media LLC versus IP Application Development LLC, number 191461, Fourth Circuit. I have given the entire citation just to help you. If you want, you can jot it down because it'll help you in fortifying your arguments before any tribunals in case you're representing your company. Well, this is a classic case of trademark squatting. And just to let you know the story, in fact, you already know it. In 1990, Apple launched, what did it launch? iMac. It launched a series of iProduct and meaning internet products. It launched iMac, iBook, and of course, your laptop and desktop. Then moving on to 2001, Apple launched the first generation iPod, a handheld music device which was clubbed with iTunes, which we all boasted of, during the teenage years. And then in 2007, Apple launched its first iPhone. Then, while Apple was booming, this much celebrated iPhone, of course, it was booming with its iPhone, RXD launched a mobile internet notepad. I'm reiterating, RXD, there was a new competitor which came up in the market, and it launched a mobile internet notepad called an iPad Mobi. If you notice on the screen, the letter I is capital here, and Apple uses the small letter I. Well, what's the purpose of an iPad? We all know, again, it's just jotting down points, making notes. And in September 2007, RXD launched its website detailing the product. But again, as we all know, there is nothing like Apple. And RXD really did not become a commercial hit. Then in 2010, Apple launched this so-called controversial device called the iPad. Mind you, it launched the iPad, which is again a touch screen tablet, and simultaneously sought the intent to use trademark under the Lanham's Act, USA, for the iPad mark, and filed relevant applications. I think it's 463 or 543, something, and with the US State Patents and Trademark Office. And Apple also engaged, as usual, as any corporate counsel would advise their IP team to do, series of other iPad registrations, of which, of course, the Fujitsu Incorporation registration was also done, long story short again. Now, RXD filed its trademark applications also in 2010 before the US Patent Office, and its application was thrown out or rejected. Now, of course, it threw, RXD was irate about this, and it launched adversary proceedings against Apple. Now, RXD's contention was that Apple's use of the mark constituted unfair competition, and RXD flouted the principle of first user. Now, again, IP professionals would know what is a first user principle. First to file, first to use, I'm sure you know that. That is, first to use is a principle that is used by the common law jurisdictions, and first to file is invoked by the civil law jurisdiction. Well, so Apple, now again, what was the contention of Apple? Apple contended that RXD had the intention of confusing its consumers. I want you to listen to this, precedent carefully, because there's a certain reason, and I'll draw your attention to the types of trademark squatters as well. So RxT, I'm reiterating, had the intention, Apple says, that of confusing its consumers. Again, long story short, the Court of Appeals, there was Justice Keenan there, and he held in favor of Apple and said that Apple indeed had a bona fide intent to use the mark and the services listed in its application. And reports say that Apple had to expend approximately $3.6 million to get the trademark back. Now, thereby, what is this trademark squatting? Of course, it's also called as trademark piracy, and it simply means unauthorized use and registration of a trademark or a brand that primarily belongs to someone else. In some cases, a squatter may also register a trademark with the intention to even extort money or even to launch a counterfeit product. So that makes a trademark squatter as a counterfeiter. It makes the trademark squatter as an extortioner. It also makes a trademark squatter as a copycat, it may be intentional copycat or an unintentional copycat. So what are we referring to here is just not mere trademark infringement or mistaken filing, but a deliberate attempt to file or register a trademark in some other country. For instance, Apple again. This is yet another case. When its trademark iPad was not registered in China, it had to shell out $60 million to get back its trademark iPad from a Taiwanese company, a Chinese subsidiary called ProView. Now, there are two important factors to be considered while resolving a trademark case, which again the lawyers would know. The two I's, that is the intent, the intention of the trademark squatter, making it easy, the two I's, and two, the impact. When any case comes before a lawyer, they see the two factors, the intention as well as the impact. Now let me substantiate this with a Samsung's case. As reflected in the famous Samsung's case, Samsung applied for an EU trademark, where the gentlemen here are quite distinguished in that field, for an EU trademark, registration of trademarks in the European Union in 2016 to protect the name of its new new phone application called Bixby. And this was opposed by the Pakistan registrant of the Bibi trademark. So he used the trademark Bibi. Later, he registered it in the Benelux region of Belgium, Netherlands, and Luxembourg. So in this case, again, the court invoked the doctrine of bad faith. Again, the long story short, the High Court of Hague held in favor of Samsung, adjudicated in Samsung's favor by nullifying the Bibi trademark and ordered the trademark squatter to pay Samsung's legal costs, and said that Bibi trademark was indeed, or that Pakistan registrant, in fact, had a malicious intention of using or registering the trademark. So as every legal practitioner knows, I would like to reiterate this. There are two principles, just to brush up our memory, that the principles that are invoked depending on the jurisdiction is the first to use principle, where usage plays a prominent role, or it is a significant factor in determining the brand owner's right over a particular mark. And the next one is the first to file, which is used in civil law countries, like, of course, even we here in UAE, or even, I guess, Paris, civil law countries, they use first to file, and India uses first to use. Common law countries use first to use. Now, Similar countries, of course, they use first to file, which means that registration may be granted to a brand owner just by way of mere registration. And then he gets an enforceable right. Just when he files the application for a trademark, who first files it? Now, what about UAE? Now, a proposed UAE, I'll go slow here. We are a civil law country, of course. We use certain principles. Okay. So we use the principles from the civil law jurisdiction, and the most recent promulgation here is the 2021 trademark law, number 36 of 21, which explicitly forbids forging. The term used here is anyone who forges. The UAE law does not specifically mention trademark squatting, or squatting, however you pronounce it. It does not mention that word, but it uses the word forging. So that means it interpretatively includes squatting. And this is a commendable legislation in the recent years, and in UAE, we are in the process of developing the laws, and we are getting there. And this particular law, it talks about inflicts penalties on anyone who forges the law or uses a forged or a counterfeit trademark for commercial purposes. And the penalty imposed under the law, the pecuniary penalty, is AED 100,000 to AED 1 million or an imprisonment for 1 year. The most interesting provision for me, according to, as per this law, is Article 50, which further conveys that whoever sells or offers for sale or circulation or possesses with the intention of selling goods or offers the provision of services carrying a forged and imitated or unlawfully put or used trademark despite his knowledge thereof. That means even if I use a trademark, just which is sold to me, and I know it is a forged one, and I kind of keep mum about it, and I use it discreetly, even then there will be a penalty that is imposed upon me, up to a pecuniary penalty of AED 50,000 up to 200,000, and an imprisonment can be up to 1 year, or fine, or both. Now, depending on the facts and circumstances of each case, the jurisdiction and the client, again, may be advised to file a civil suit as well as a criminal charge. Now, this is something to think about, what UAE does here. A civil suit and a criminal charge. Now, here, civil suit, for lawyers, of course you know about this, civil suit and a criminal charge in UAE does not work concurrently, right? But in India, a civil suit and a criminal case can go together. However, the court may file an application saying that let the civil suit be stopped till the criminal case is adjudicated. Now, further, UAE is interestingly a party of several international treaties relating to intellectual property. Of course, the famous Madrid Protocol. Then apart from that is the Berne Convention, the Paris Convention, the Rome Convention, the WIPO Convention, Copyrights Treaty, the Patent Cooperation Treaty, TRIPS Agreement, and so on. I would like to draw your attention also to the fact here about the Paris Convention. And there's a reason for this. I'm sure you know, being intellectual property experts, that the Paris Convention was actually the one which prompted the advancement or the setting up of WIPO. So the Paris Convention was actually convened way back in the 1800s. Now, Article 6 bis, that is a clause that is interspersed between Article 6 and the next article, Article 6 bis of the Paris Convention, and Article 16 of the TRIPS Convention explicitly details about trans-border reputation. We heard this morning about the principle of trans-border reputation. So this principle is actually, again, a significant element and provides that if a mark has not been used in a specific country, but has established reputation in that country as a result of international usage, the trademark may be protected in that country. Now again, we have legislations, we have conventions, we have clauses, we have even WIPO clauses, but how far it is effective, even in the light of this particular principle, which is, again, a clause which is interspersed between 6 and 7 of the Paris Convention, and of course, even Article 16 of the TRIPS Agreement. So what's the solution? Living in a world which is set to have no borders when it comes to business and trade, what is a solution to the risk of trademark squatting then? Through the sessions, we have been hearing about, different ways of resolving trademark infringement, trademark disputes, what can be done after we are attacked. So my question is, what can be done before you're attacked? And what can be done, in fact, to obliterate trademark squatting? What has to be done about it? Some may feel that, well, what you are talking may not be practical enough, but in my humble experience of few years, of course, unlike some of you who are much senior than me, I just hold around 17 years of experience, where some of you may be in 20s or more than that. In my personal experience, a lawyer, an in-house lawyer, can play a very important role in curbing or even in obliterating trademark squatting. Now, the thing is that we need to discourage the menace of trademark squatting and not just prevent or implement solutions or advise solutions as a victim or for a victim. Now, some lawyers, you already know this again, some lawyers advise, if you ask any lawyer, in my experience, because in my circle, if you ask any lawyer, at least from China, at least, so when you ask them, what do you think is a solution to obliterate trademark squatting, sir? He says, no, come and register your trademark in China. Why? Because, there are apparently many cases which are rising from China. So if you register your trademark in China, then of course it would be one of the principles to, they didn't use the word obliterate, but they said that you can just shut the door to the enemy. But for me, again, in my humble experience, reiterating, that's not the solution. Because why? I have been into policy making. The little that I do to protect my company in whatever field it is, I devise policies for my company in the way that its trademark is protected. Its trademark is, it is not attacked, or just not trademark. Let it be trademark, or let it be even HR policies or CSR policies. And I believe in practical implementation of things and not just a beautiful story. You see, so lawyers can play in-house counsel, but whatever position you may hold, a manager or GC or head of department or legal counsel or junior counsel, we play a very important role in-house in advising policies to the top management, in devising policies, in reviewing policies in the best interest of the company, and we protect it. This morning, there was a P&G council you were talking about. I was very distinctly hearing your talk, and I was hearing about how you endeavor on behalf of your department to protect your trademark. So that was interesting as well. So you were talking about software, right? Software and how your R&D works. So again, software, having a software launched in a company to constantly monitor whether there is any trademark infringement. Again, is an interesting move, and people do that. Next is, again, countries like India. We have heard about it a lot today. Transborder reputation, remedy of passing off. And again, the council who was there this morning, she said that there is 3 elements that needs to be proved for passing off. As usual, in the law of torts, 3 elements: misrepresentation, prevalence of reputation, as well as the damage caused. I'll not go through that again in detail. So internationally speaking, or generally speaking, on the other hand, if there is a case of trademark squatting, the most common solution advised by all of us, forget about trademark squatting. Say that you are part of a law firm, and then you get a client and a case. So I've been a part of a law firm as well, so what do we advise? We say litigate, right? We say just directly litigate. Come and file a case. And so sometimes I would advise companies to just let your lawyer decide whether to litigate or to negotiate or to do whatever, because the lawyer possesses the skill and the aptitude probably to negotiate on your behalf and to nip the matter in the bud. There is a possibility to nip the matter in the bud. Well, the other thing someone would do is deregister. There are companies who have even deregistered themselves. Okay, I give it up. Why don't you deregister? Next is you enter into a bipartite agreement with the squatter and get back your trademark. And you know who has done this? Apple. Apple entered into a bipartite agreement with the trademark squatter and purchased its trademark back for $60 million, a whooping sum. So again, is this prudent? So if they are doing this, are our laws strong enough to leave alone obliterate, but even curb? Now, why I'm saying this? I'm a student of international law, and also I have been a student of comparative laws because I love comparative study of all the laws. And and I'm also a practical person. And I always love to observe what nations do. At least in my experience in UAE, apart from trademark, if I am allowed to talk about something else apart from IP, because I'm sure you heard a lot of IP, let me talk about this. At least in UAE, when it came to the COVID pandemic, I know, forget about as a lawyer, but as a normal resident of this country, what UAE did to secure not only its citizens, but also residents. And I mean, I don't mind saying this, that at least by the press reports, no other country, I mean, I'm an Indian, I'm of Indian origin, and Asian, whatever you may call me, but no other country in the world has taken steps, I'm telling this in a public platform, like how UAE did. Everybody talks about their own financial structure, but UAE did go, much ahead and took number of measures, did vaccination drives, be it residents or nationals, and protected the interests of everyone who's living in UAE. It also has stringent laws, and I am for stringent laws. I am for stringent laws and not laws that relax. I am for stringent adjudicatory mechanism that operates as a deterrent mechanism, not something that gives leverage to a criminal who says that I think I can sneak out of this. And not like a criminal who says, I can play the hide and seek game. No, I am for a stringent mechanism. As a lawyer, as an in-house counsel, I have devised stringent policies for the company, be it HR policy, be it trademarks, be it even whatever IPR, copyrights, and I have the experience, of course, I've been into the aviation sector. I was discussing this with a gentleman yesterday, that I've been a part of the aviation sector, and aviation sector agreements runs in 200 pages to 300 to even 1,000 pages when it comes to PPE agreements, public-private enterprise. So I feel it's a skill of a lawyer, whatever or how much you know, to understand that you know nothing, to be blank and to go through the contractual pages and then secure the interests of your company. So therefore, I would say that we have solutions to combat, but no tools to discourage or obliterating this act of trademark squatting. So what more can be done? Now, I propose to bifurcate my further discussion on obliterating the issue on what can be done at a macro level as well as a micro level, and some of it is already being done. But my suggestion at a macro level would be who else besides WIPO can lead? A strategic move is the key. As I said earlier, having read the WIPO clauses, some of the clauses, to be frank and honest enough, meticulously, which actually advises on what can be done on trademark infringement, and it also advises on companies to promulgate domestic laws to curb trademark infringement. So who else other than WIPO can lead? So I would say that, advisably, WIPO has to devise stringent regulations through conventional clauses, and of course the state parties or the signatories should be able to abide. And of course the clauses should be rational and to aid effective implementation. What can be those strategic clauses? I think we could take it in the question and answer series, or I think it's quite professional enough because it has to be tailored clauses, and again, it is of international regime. So what would really make a difference is each country has to fortify its laws, its IP laws, in consonance with WIPO norms, treaties, and conventions. Now, why I'm saying this? In the light of the news that we have been hearing, and of course, we have our legal gazettes and journals which have published this. We all know about the sad situation in Russia and Ukraine, where there are some prominent companies like McDonald's, Nike, etc., some of the companies who are in Russia. They imposed sanction on Russia and said that we no longer want to be a part of this because I do not know. So they are not in line with the thoughts like Russia, whatever reason. I'll not go into that. But the thing is, what Russia did in response, after the sanctions were being imposed, Russia promulgated a legislation saying that, we have got a lawyer from Russia, so he's the one who should teach us more about it. So it promulgated a legislation saying that now you can, register your trademarks by whatever name. And there was one of the companies which registered a trademark just like McDonald's. But the difference is, McDonald's is an M, and the other trademark is like a B. There's another company which launched a trademark just like Nike. No changes. So question, how far is your domestic regulations, directives, whatever, legislations, promulgations, whatever name you call, how far is it effective? As a lawyer, or as you all are lawyers, in-house counsels, or even whatever designations part of big organizations, or even international organizations, what is your advice to this? I will take it up in the question and answer session, no problem. I'll do that. But this is something for us to think about at the back of our minds. Are we effective at whatever we do and wherever we are? Whatever little we do and wherever we are we effective? Are we utilizing the knowledge that we have in securing the rights of probably your client or your company? Well, the next thing is a tracking system. My learned friend already, he discussed about it. And yet another thing is, what Apple did. This is, again, I think most companies do also. Apple tried to shield itself and safeguard its trademark by listing all its trademark on its website, of course with certain policy specifications adumbrated there. Next is, again, coming back to my opinion, lastly, it depends, again, I would like to reiterate and thump upon this aspect. Rather than just talking about the existing laws, which you already know, the thing is, like, it largely depends upon legal counsels like us with eagle eye vision. I'm sure you know eagle eye vision, where you can really gauge something from a distance, interpret laws, interpretation of laws, avoid while you're drafting wide interpretation of the particular clauses, where we have got distinguished skill to foresee and certainly thwart certain conflicts, of course, in your expertise and support your organization or client. And now I would like to leave you with a question. What about squatting of dead trademarks? Before I close, I'd like to go even through the WIPO's definition of trademark squatting, so that probably we would take it up at the question and answer session. Now, WIPO's definition of trademark squatting is the registration or use of a generally well-known foreign trademark that is not registered in the country or is invalid as a result of non-use. In the light of this, I pose a question to you. What can be done in case of squatting of dead trademarks that were once upon a time famous and now no longer in use? I'm not talking about resurrect the dead trademark or refile or that. What can be done to obliterate trademark squatting of once upon a time famous trademarks, that are dead today? And of course, I did not talk about the Madrid Protocol because already it was discussed this morning, and just to brush over that aspect as well, because I feel it is incomplete without me mentioning about the Madrid Protocol, the famous Madrid Protocol. We all know that it covers 112 countries. So if you register your trademark under the Madrid Protocol, you conveniently cover 112 countries there. And apart from that, yet another thing what the corporate councils can do is register your trademark in maximum jurisdictions, at least by that I mean, but at least in key jurisdictions where you anticipate launching your business. So that's one of the things. Well, ladies and gentlemen, this is Henrietta Newton-Martin with you, and I think question and answer can be taken towards the end of the session. Thank you so much for your patient listening.
Thank you so much, Henrietta. It was a great presentation. Now, our next speaker is Richard Milchier. He is the associate lawyer and partner at Herald, France. So Richard Milchier is a partner in the IP and Competition Distribution Department. He specializes in intellectual property law, European Union law, competition law, and health law, and has argued cases in front of the French court, the General Court, and the Court of Justice of the European Union in Luxembourg, and also in front of the French and European IP offices. He was admitted to the Paris bar in 1979. After graduating from the Paris IEP Sciences Pro, Richard Milchier turned towards law with an honors degree in private law, University of Paris, in 1978, which he supplemented with an honors degree in economic science in 1979. Ladies and gentlemen, here is Richard Milchier.
I have my presentation, please. So while he is looking for my presentation, first I have to say that I thank Henrietta because she was quoting Blaise Pascal, a French philosopher, and his most famous sentence is, I believe in God because I don't know if it exists, but in a way it's worth it to think that he exists because who knows what's happening after. And I also have to thank her because she left one mic working because she already broke two. And therefore you can listen to me. And I will also say that I partially disagree with her, and that's the interest of a panel, because trademark squatting is something which is not new, and I don't think that we can solve the issue whether by additional international convention, national regulations, whatever, because humanity has been trying to get rid of thieves for thousands of years, and we still have thieves. Humanity has been trying to get rid of war for 1,000 years. We still have war. So that things, trademark squatting is not as bad as war, but it is something which exists, and we can only try to solve this on a case-by-case issue, and not general through general regulation, which will be interpreted by lawyers and by courts in several countries, and we will come back to we will come to creating additional issues or new issues instead of old issues. So now, if I find it's here, yes, wonderful, it works. So I do not have a general definition of trademark squatting, but I'm going to try to give you some examples and some type of trademark squatting I have seen or I have lived. And what do you have? And it goes back to, or it is included more or less in the definition given by Andreita coming from WIPO. A first type of trademark squatting is when you registered, when your trademark is registered in the same classes, but in a country where your trademark is not registered. The second type is your trademark is registered in a country where it is registered, but for other products or services, because you did not register because you had no use about that. And I will tell you more about a story or a case I lived concerning that type of trademark squatting. Another type of trademark squatting, which is much more difficult, is so your trademark is registered in a country where you are registered, but it is registered in another alphabet. And so in Europe, at the IIPLA, the official characters, alphabet which is used is a Latin alphabet. But in some countries, for instance here, in China, in Japan, in Russia, so in India, you use other alphabets, and you may have a word which is written with different letters, but with the same pronunciation. You may even have different alphabet inside a region. For instance, once again, inside the EU, we use mainly the Latin alphabet, but Greece use the Greek alphabet, Bulgaria use the Cyrillic alphabet. So we have, just for one region, the EU, we have 3 different alphabets, even if only one, as I said, is officially used by the IIPLA, the office in charge. So who does trademark squatting? Mainly what was called originally the pirates. You all know, I assume, what pirates are originally, and this word was used to define the trademark squatter at the time where the word squat or squatting was not used to describe that. And that's important because what is a pirate? A pirate is someone, and they still exist, who is attacking repeatedly one ship after the other, one trademark after the other. You have some, let's say, compulsory trademark squatter. You also have another situation which is less important in percentage but very annoying for the trademark owner. It is the situation where, which exists when you are the trademark owner. You start to distribute your product in another country with a distributor. You have an exclusive distribution agreement, and your nice distributor tells you, don't bother about registering the trademark. I will do it for you. Fine. Take care of that. Then, a few years later, end of the distribution agreement for whatever reason, and the distributor tells you, oh, it is my mark. And then you try to recover it. Good luck in certain countries. It's a situation I have known too, and obviously that's something, in addition to what Henrietta was saying, which is to be understood by the in-house counsel, general counsel in the various companies when you want to enter into a country. So better protect your trademark before starting the negotiation with anybody, because it's, as you all know, it doesn't take long to file a trademark, but it takes a long time and a lot of money to recover it. So how do you defend yourself as trademark owner? So here I will, in other words, join what Henrietta was saying. So you have to define, she was speaking about policy, I will speak about strategy. You have to have your strategy because first, we heard that yesterday, the companies have a budget. That's a word I hate when your client tells you, we have a budget. Oh, try to work without budget and just pay my bill. But they have a budget, and you cannot protect anything, everything, everywhere. So therefore, you have to know where you are going to produce, sell your product, and you also have, at least that's the advice I give to my client, to consider that there are some countries which are infringing countries. China, Japan in the 70s, everybody forgot that, was considered as the major infringing country in the world. China was considered as a very big infringing country. Things are changing in China. So other countries will become infringing countries. You have to protect your trademark in those countries where you may have some infringements which will be made, and obviously you have to balance this this policy with the fact that you are limited by the size of your budget, whatever your budget is, and whatever the size of the company is. So, nevertheless, this protection is not perfect, because I will remind you, you know that in some countries, if you do not use your trademark for certain products or services for whom you register it, you can be subject to forfeiture for lack of use action. Or in other countries, you have to file, like the US, you have to file after 5 years a declaration confirming that the mark has been used. Or in other countries again, sometimes if there is no declaration of that type, the office can directly decide to cancel your trademark or part of your trademark. So therefore, the protection granted by the fact that you will find your trademark in countries where you do not use it is evidently limited in time. But when you are starting to a company, it's important. You also should have in place a watch service. You all know, or I assume that you all know, that there are companies, I'm not making any advertising, who are offering that kind of service. And you can do that with your local counsel, with your foreign counsel, because it's important to have a watch service, but it's important to decide after that if you want to follow up once you have received a watch information, because it's easier to stop a trademark before it is published or before it is registered in certain countries, means the opposition proceeding are maybe very effective and certainly less costly generally than having to go to court in whatever country you speak about. So, therefore, if you see a trademark appearing that you consider as a trademark which is quoting your trademark, you may, in some countries, defend yourself on the basis of bad faith, when bad faith is available in the legislation of that country or region. I'm not going to try to define bad faith because it's something that nobody can do it, and even speaking as a EU lawyer, the European Commission refused to add a definition of bad faith in the trademark regulation. The Court of Justice gave some information first in the Lind case, which concerns the golden rabbit chocolate, if you know it, and I'm sure that our German friends know it. But more or less what the Court of Justice said is that you know that bad faith exists when you see it. And let's say it's a kind of circular definition, and I will not go farther into that. An important situation and difficult one is the one of transliteration. Transliteration is when, so you have the sign, the mark, written in a certain alphabet and filed in another alphabet, usually by a pirate. It is something which that I have seen quite often in China for some of my clients, where my clients were filing their trademark in Latin alphabet as the original trademark they had in France or in Europe, and suddenly you discover that you have something written in Chinese character, and it is the same, either it is the same pronunciation or it is the same word with a different writing, but in any case, it is something which may be filed by a private for the same product and or services than the one you are using, or for different products and or services. But in any case, it is something which can be used to bother your client in China. Therefore, another piece of advice I give to my client, especially when they want to do something in China, is, and I'm not the only one to say that, I don't pretend to be a genius from that point of view, is if you have the money, file in Latin character, and you have to remember that, so when I read a word in Latin character, I mean, I read it. When I read a word in Chinese character, it is an image for me, because I don't know how to read it. And therefore, the Chinese consumer in the street, when he sees a trademark in Latin character, for him it is an image. But when he sees the same trademark written in Chinese character in China, he can pronounce it. So this seems obvious, but nevertheless, when I tell that to my client, maybe my clients are dumb, but it's always something new that they discover, and they never thought about that. So now, how is the issue of transliteration solved by office and court? Obviously, I don't know how it is in every country. I don't pretend to know that, but as I said, the visual comparison may be different, but the phonetical comparison can be identical, and the conceptual comparison may or may not be similar or identical. So to give you some example, I think I will skip that, but in a recent case decided by the General Court of the EU in November last year, so you see it's quite recent, the mark at stake was Police Lutron, sorry, as you can see. And what is interesting is that the court recalls that concerning the interpretation of the mark, that the two words used are transliteration of Greek words, and it reminds that the case law of the EU states that the transliteration in Latin characters of Greek words must be examined as word written in Greek. Obviously, that's a solution which is valid for the EU. It may not be valid in other jurisdictions. Another case, recent case, less recent from 2021, you can see in red the two marks at stake were Gruyumi burger, and now that's the limit of my presentation. I cannot pronounce the first word, but the second word in Latin character is halloumi. And this mark was, so therefore Gruyumi burger was opposed on the basis of the two words mark finishing by halloumi. And they were filed for food products. Yeah, okay, so a nice reminder. So that gives you an idea of the issue that can happen. I will stress a little bit more, concerning this one, because it's interesting for several reasons. First, it was decided on June 2022, so meaning after the beginning of the situation in Ukraine, and it concerns a mark filed by a Russian company. And it's a case from the European Court, of the General Court, sorry. And as you can see on the top of the image, in fact, you cannot read it when it is presented like that. You can read it on the product because the words are inverted or inversed. But what is interesting, it was, in fact, opposed by, you can see, a mark composed of two words, so in Cyrillic character. And strangely enough, even if the sign was, which was opposed, was filed by a Russian company, the court explains that the word, I'm sorry for the pronunciation, krovka, which is a word you have seen on the first image, is a Polish word, unlike the two other signs which I have shown to you. And in that case, I have to speed up. So in that case, it was decided that the opposition should be refused. So I have a few other situations you see here. That's a French decision where you see the signs which were in conflict. So for me, it's a type of trademark squatting. And in that case, a Dutch company opposed the registration in France on the basis of its international registration of the mark Kemchipaya by a Russian company. And this opposition was upheld by the Court of Appeal, notably because, no, I mean, I will skip that, sorry. And another case, which is a little bit more recent, you see the two marks at stake, it's only the sign omega, and here, and at the bottom you see it's also omega, but with an additional, I don't know how to call that, visual, and then a letter B and nat, and it was decided by the Paris Court of Appeals that the opposition should be rejected. So what do I want to say with that? And that's this case is also interesting because it's a very unusual case where you see those two signs, which were not in Latin character, but and which looked very similar, but in fact, it led to a situation where the opposed mark was considered as infringing, but nevertheless, it was infringing only for a certain period of time, because after that period, the opposing trademark was cancelled for lack of use. So it's a very, very unusual situation. So what am I trying to show you with that is trademark squatting is not so obvious, because I have very quickly presented some example to you of signs which looks, I will say, more or less similar. I will not say identical, but more or less similar. And you see that sometimes the opposition is granted, or it is decided that the mark is infringed, and sometimes it is decided that it is not a similar trademark and that the opposition should be rejected. And what does that mean? That means just the obvious. As a trademark owner or as a lawyer representing a client, you are certain that the trademark of your client is infringed, or that your client is not guilty of anything. And if you are not convinced as a lawyer, you cannot defend your client anyway. And where is the truth? At least the truth of the moment. The truth is either with the office and the decision of the office, or with the judge. And therefore, I will not scream saying that we should do whatever is possible to stop trademark quoting, because sometimes what I have seen as trademark quoting was finally not considered as trademark quoting, and as a lawyer, I have to respect the court because they have the final law. And sorry, and just what I forgot to tell you, because I went too fast, is about compulsory pirate. An important point is that in some cases, like the one mentioned by Henrietta, you have one situation, Bixby, BB, one time. But I've seen pirates where that, and in fact it was funny because my boss had seen them, the same person being a pirate 15 years before. And when I fought against that guy, he had registered in France Harley Davidson, a mark you don't know, American Express, a mark you don't know, the mark of my client that I will not tell, Club Méditerranée that you may know, but for, I don't exactly remember, but Harley Davidson, it was for food, American Express, it was for clothes, and so on and so forth. And this, we were a bunch of lawyers fighting, we were 32 lawyers representing 32 marks filed by these pirates. And in that case, I will say it's easy to say, so you have a guy who is a compulsory squatter and you have to stop him. Sometimes, as in the example I showed you, it's a one-time issue and the discussion is open. So therefore, I think it was important to, let's say, sorry, Henrietta, to balance a little bit what you heard before. I do not say that I have the truth because, once again, there is no judge and there is no court, so nobody will tell us the truth for today. Thank you.
Thank you so much, Richard, for the valuable insights we had. So now next speaker is Sergey Medvedev. He's the partner and head of legal at Gorodsky and Partners, Russia. And the session is yours now. Thank you.
Thank you very much. Yes, we are a bit of time, and we need to pass the floor to Elizabeth also. So I will try to be quick and not so boring. Yes, first I will start with, I don't have a presentation, just a few comments on trademark squatting from the side of internet and domain names. Nowadays, what we see, as Henrietta and Richard already mentioned, that squatting happens through registration, use, imitation of brands, and that happens on products and services. But we also encounter different cases online because of the digital era and development of different IT systems and economy as well. So what we see trademark squatting on the internet, in domain names, in social media. We also see some websites which are cloned, and every brand owner need to be prepared for that as if it was a regular trademark squatting. I mean that the trademark owner and of course his lawyer must understand what options are available to enforce trademark rights. Like Henrietta mentioned, we need to understand laws. The laws must be effective, and trademark enforcement mechanism must be feasible for the trademark to be enforced. So generally there are different options if to speak from the international level, and many of you have already worked with them or offered them to your clients, or maybe you as the client have already practiced them. First of all, what we should differentiate is the amicable or non-amicable way of domain name settlement. We would recommend our clients domain name purchase versus C&D letter. That's how the case would usually start, and many of you knows about that. So the domain name purchase can be done through anonymous detective, and Elizabeth will talk a bit about that. Usually we would hire the detective who will quickly chat with the pirate and maybe offer some money, or maybe the pirate will offer himself just a bit of money, and it can be a quick transfer and feasible just because you need this domain name, and maybe for you it's not very optimistic, or maybe for you it's a long way run in the litigation, so you will choose the domain name purchase as the first option. Comparing to the second option, when, for example, you see that there is no answer from the detective or from you when you start chatting, you can send a cease and desist letter, because for you it can be a good start and good evidence in the court if you are preparing the court action or another administrative action, which is also possible. So C&D letter may work in many cases, especially against non-aggressive infringers, which register the domain by non-knowledge or by mistake or something, and it can be a case, and we happened to have these cases in Russia when the domain names were transferred even without payment to the real brand owner. That are like the very first options that lawyers and brand owners would use, but there are also very nice international mechanisms which were created by ICANN and administered by different registrars, which we should mention right now as well. I'm talking about UDRP and URS mechanism, which we call in Russia administrative, but on the international level they are called more arbitration mechanism, because they are quasi-arbitration mechanism where you don't need to show up in court, or where you don't need to litigate. The only thing you have to do is to present your position in the statement of claims, and the respondent must submit a response. Otherwise, the chances to defend the case are very low. So, what are the differences between such international mechanisms and options which are available against domain names? URS. The URS only applies to new GTLDs, and new GTLDs were launched in back in 2013, and then there were some reforms. The UDRP applies to all GTLDs, including some new GTLDs and some CC, I mean country codes and zones. For example, Russia doesn't adhere to UDRP. That is why in many CIS and Eurasian countries, which are kind of becoming popular right now, because they do not adhere to UDRP, you won't be able to start your case in the WIPO arbitration or other, for example, an NEF forum or other institution. Remedies. This is very important because when you advise the client, you have to provide the main goal and what the client will receive. This is where these two procedures differs. For example, under URS, the domain is suspended for the remainder term of the domain name registration, and it can be extended for 1 year, as the rules are saying. So basically, you can get about 2 years or a year plus some months of pirate domain name suspension. But here, the client may ask a question: what happens next? So this suspension period expires, so it means that the domain name can again be registered in the name of a third-party pirate, and the case will need to be started again. For the UDRP proceedings, the domain name is transferred to the complainant or cancelled at the complainant options. This is nice, especially when we are looking for some pirate domain names fully identical with our brands. We need these domain names in future, and of course we don't like when it's when the pirate fully takes this zone and doesn't provide us an option to appear in this jurisdiction. Well, filing fees, I will skip it. For panel, yes, the single expert or 3 expert panel is available for UDRP. For URS, it's single examiner at the first instance, single examiner or 3-member panel on the appeal. This must be taken into account in a sense that the 3 experts may provide better knowledge and more fair decision. The criteria are all about the same. I mean that URS basically copied the 3 criteria of the UDRP, which are that the domain name is identical or confusingly similar to the trademark. The registrant has no rights or legitimate interest in respect of the domain name. The domain name has been registered and is being used in bad faith. So the last 2 basically relate to cases when the domain names are basically non-active, which means that they are just registered but not delegated to any sort of content. And here, for example, in Russia, we may have some problems in proving that there is clear-cut infringement, because under Russian law, for example, the trademark infringement is when you use the trademark in connection with registered goods and services, and if there is a likelihood of confusion. But Russian court practice has been promoted, and we also followed the international principles of UDRP, but in court. So you have to be in front of the judge and you have to litigate, showing all these criteria. We call them UDRP criteria, and you can get the domain name re-registered to the brand owner. Speed, in terms of speed, in UDRP, who filed and practiced that, you know that it's about 2 or maximum 3 months, depending again on the panel and on the activeness of the respondent, versus about 20 to 30 days of URS, because URS is a quick mechanism. Standard of proof is different. For UDRP, it's clear and convincing. For URS, it's preponderance of the evidence, as the rules say. That's why for like the lawyers who tested many cases, they say that URS is more kind of difficult in terms of evidence that you need to bring in front of the expert or who will produce the determination. Appeals, so for URS, the appeal is not possible. The defendant can start new URS proceedings against brand owner to confirm his rights in the domain name, while in UDRP, respondent notifies ICANN within 10 days of a decision that it has commenced proceedings in a court of competent jurisdictions, and ICANN will stay the transfer or cancellation of the registration. That's how my comments are written, meaning that it will not immediately transfer, for example, to the brand owner if the respondent has started litigation in local country. We have had these cases in Russia when UDRP case was lost, but then we have prevailed successfully in the litigation and overturned the decision of the UDRP. So there are other, of course, requirements and features of each proceedings which you as a lawyer have to understand and report to the client. But again, the main thing is that UDRP allows you to transfer the domain name, which is good because you may pay a few amount of money to maintain the rights, even if you don't use it, but it won't go to any third party, as for example, under URS, after the suspension period, again, any can register. And there is another option which you should take into account. I'm talking about litigation. For example, in Russia and other Eurasian countries, like Kazakhstan, for example, you have to litigate to recover the domain names like RF, SU, RU, and the litigation process is is not so long. It can take about 6 months usually for the first instance court. There can be an appeal, but the appeal is kind of quick. It's about another 2 or 3 months. During this process, there may be a settlement because the pirate is not ready to pay money to the lawyers, for example, or to do anything. But you, as the brand owner, must understand that you have to block the domain name during the process, because otherwise the pirate can re-register it to another party or change the registrar, and the case will be dismissed. So you have to take preliminary actions or preliminary injunction to win the case. By the way, under URS, it is status quo on the domain name, meaning that the pirate can still continue using it. For UDRP cases, maybe some of you know that already, but it has to be emphasized that the domain name is blocked until the decision is issued, which is very nice because the infringement doesn't continue. So depending on the obstacles of this domain name squatting, we have to balance between all these actions and understand which option is more preferable depending on the jurisdiction, depending on the level of protection and enforcement, and of course depending on the budget, because Richard already told about that. For the clients, especially involved in digital business, they know how to calculate money, and if there are thousands of domain names, you cannot spend thousands and thousands of dollars to stop all of them. You would prefer CND mechanism, CND letter mechanism, or arbitration measures as UDRP, as I mentioned. By the way, there are some legal tech platforms which provide automated regime of sending CND letters. Is becoming more and more popular. I'm talking about Mark Monitor, Red Points, We as a firm created a similar IT service that can provide monitoring infringements and sending cease and desist letters and takedowns in the automated regime, in the AI regime, without inviting lawyers' hands, and again, it can save a lot of money. That's it. Thank you very much for giving me time to speak. Regarding what Henrietta mentioned, just quickly, Russia has not produced any laws which may negatively influence brand owners. We permitted parallel imports to some goods, but not all goods, as mentioned in the media. McDonald's trademark application was withdrawn by the applicant. It wasn't registered, but it was like distorted that they gained rights. We have not seen a surprise here. We see pirate trademark registrations every day in Europe, in US, in Russia, in China. It gives lawyers work. It's standard things which we can encounter. It was like, you know, overturned. Yeah, it was changed like that. But this, even if applicant would proceed, would continue, RUPTO would cancel, would not allow this to register because the rules did not change. You cannot register the confusingly similar or identical marks. And we have spoken with Richard before, just before the speech, and we were discussing the Peppa Pig case. I think it was like the president for everyone in the media. It was just the first instance court decision, which was immediately overturned in the Court of Appeals and supported by the cassation. It was mentioned that the UK company, which was the copyright holder of this toy, which was sold and offered on the internet. It was from a non-friendly country, from UK. But the Russian IP court emphasized that this is not the criteria that the court must apply. We have IP rules. We have criteria and factors which needs to be proved, that the trademark owner is a trademark owner, that the use was unauthorized, and it was likelihood of confusion. Everything was proved, so the decision was overturned. We do not see that there is any aggression against even non-friendly countries. The laws, again, were not changed. Only parallel imports were allowed to some kind of goods, but parallel imports, it's about the business, not about the legal thing. In many countries, they're allowed. Thank you very much.
Thank you so much, Sergey. Our last speaker for this session is Elizabeth Carioni. She is the detective. She's in the Detective Bureau, Russia. I would request Elizabeth to just take 10 minutes because we have already taken up our break time as well.
Hello. I am representative of the Russian Detective Bureau, Carioni. It is one of the oldest and trustful Russian detective bureaus, and we work not only with Russian clients but also with Europe. So I just want to give you some information about how a detective and a lawyer communicate in cases involving the intellectual property protection. Okay, let's wait for the presentation. Thank you. So in my speech, I will talk about the main method of finding and fixing evidence of illegal use of trademarks, inventions, and utility models. When the copyright holder is faced with the problem of stealing a trademark or invention in order to protect himself, he turns to a lawyer, of course, or patent attorney. But sometimes lawyers do not have enough things to prepare a claim. I'm talking about, for example, if the lawyer does not have an exact address of the offender to send a claim, or, for example, not full name of the offender, or, for example, the lawyer doesn't know the title of the recipient of the claim, recipient position. Sometimes we had this in our practice. In these cases, the lawyers contact the private detectives to help them. In my presentation, I just want to tell you how real private detective works. It is not Sherlock Holmes. It is like absolute as a profession. And there are strictly prohibited things lawyers cannot do. Detectives cannot do, and lawyers, of course. And I will tell you that. The first thing, when you, for example, open Google and type private detective, you will open the first link, and you will see that these private detectives investigate adultery, give alibi services, and so on. This is absolutely illegal, and private detectives do not do that. They have to. Okay. So how they have their detective status? Detectives should be registered in the register as an individual entrepreneur, and they have to have a license. The ones who investigate adultery do not have a license. That's 100%. And a little bit about the detective statistic in Russia. There are no more than 380 private detectives in Russia. This is not much, and these are detectives that actually works. From whom conduction of private investigations is the only source of income, except teaching or doing creative activities. So there are some rules of detective activity in the Russian Federation. You can see it on the slide. And what private detectives cannot do. They cannot give out himself for employees of law enforcement bodies, transmit the license or its copy to another entity, to forge materials or to mislead the client, and so on. You can also see it on the slide. And, of course, prohibited types of detective cases. So no adultery, no alibi, no child's removal from parent, no wire. Also, we do not do computer and email hacking, and we do not do commercial bribery. But so what we do? This is what we do. We do defamation and insult investigations, due diligence, cyber investigations. We also investigate terrorism cases and insurance investigations. investigation of insurance fraud under contact with a lawyer or insurance company, due diligence under contact with a lawyer or company, not like direct, and cyberstalking on behalf of website owners, patent attorneys, or lawyers. And what techniques we use when we investigate. Photo and video shooting, survey collect items, analytical procedures, and so on, and collection of documents. What is it test purchasing? It is a complex type of private investigation in which the detective acting as an individual entrepreneur and we collect goods or services from the offender in order to collect evidence of the misuse of intellectual property objects under contract of sale or under contract of gift. And in the next slide, I'm going to show you this method. So this is how we do it. So we have an order. Then the detective who collects the primary data then goes to purchase samples of goods, collects evidence, and then the lawyers can use this evidence on the court. And this is not only the documents the detective collects, also some printings, also the detective can buy some goods or contra fee. Also the detective do some photographs and finds out the addresses of the offices, warehouses, and the volume of goods. And then the detective write a report with an attachment of all that he have found, and then this report goes to the court. Then I just want to show you some sample test purchases that our company have done. Just some photos. So this is the first one. In the first picture is my father, actually. He's the owner of this company. This is a case of the search for information, the facts about the seller and test purchase of contrafeit gymnastic loops. Then you can see the illegal use of the trademark in a cafe. You see that it looks like KFC, yeah, but it is not KFC. Then it was the illegal use of the invention of the operation in the pool. The thing that can create a wave. This is the office and warehouse storage of counterfeit mobile phones. Yeah, there's more photos. There are the detective warehouse for temporary storage of counterfeit goods. As the slide shows the warehouse, inside the container you can see the counterfeit goods, which were the subject of investigations by our detectives. You see there are a lot of things. It's laminate, parquet, engine oil, ship paint, excavator crowns, and each of these crowns is weighed 50 kilograms, and so on. So there are a lot of things. In conclusion, I think it's worth to hire for collecting evidence in cases involving intellectual rights due to the following factors. So detectives, they have special skills, techniques, and equipment to collect evidence in the case and to do it right. and it is exemption for the lawyer conducting the case from tasks that are unusual to him, and using the detective's report on his testimony as evidence. It is legal. You can use detective's reports on the court. So that's all that I wanted to tell you. I just did it very briefly, and I hope you now have some information about how detectives works. Thank you very much for your attention.
Thank you so much for keeping it short. I really appreciate your cooperation. So now I'll hand over the mementos to all of our speakers. All right, thank you everyone. We'll now move to our last session of the day, which is session 5th. This is Europa application of artificial intelligence in medical field. The panelist for this session is Michael Angelo Barba, IP Counsel, Bergen, SPA, and the Pro Knowledge Limited, Italy. So I'll give you a brief introduction. In the meantime, you can, yes, I'll open that presentation. Let me just give your introduction, okay? So Michael Angelo is a PhD in electronics at Politecnico of Turin, Italy. Previous work experiences include Alenia Spatial System Groups responsible for the telecommunication subsystem design, testing and assembling for Hipparchus satellite of ESA, Metra Space, Ericsson CLT, University of Turin Faculty of Informatics since 1990 to 2020, Chief Examiner at the European Patent Office from 1990 to 1997 in The Hague, and from 1997 and 2010 in Munich, and from 2010 to 2020 in Berlin. He specialized in the field of complex mathematical algorithms, health and medical informatics, and bioinformatics, a specialist in computer-implemented inventions, artificial intelligence, and machine learning applications, and complex applications since 2021, and he's off counsel at Bergen SPA and Pro Knowledge Limited. Here is Michael Angelo. This morning, did you send it to anybody? Okay, okay, we can just it's a Mac.
I promise you that, oh, yes. I promise you that I will try to be very brief because everybody is waiting for the, and my presentation deals with the application of artificial intelligence to healthcare informatics. Yeah, it's working. Yes, healthcare informatics. I hope that many of you are aware about the meaning and about the use of artificial intelligence. And then the idea was to divide this presentation basically in three parts. In the first part, I was planning to give some definition concerning artificial intelligence. In the second part, I plan to do some, tell you some wording about how the European Patent Office deals with the patent concerning computer implemented invention. And at the end, I would like to give you some examples of the application of artificial intelligence to healthcare system. If you know already what does it mean artificial intelligence, which are the components of the artificial intelligence, we can go directly to the part related to the EPO. Just tell me. Okay, let's start very briefly. The word in artificial intelligence is composed by two wordings: intelligence and artificial. Intelligence is a very broad concept which has its own definition in a computer environment and has a different definition from, let's say, the biological point of view. We are interested to the definition concerning the computer environment, and there are, let's say, on the market many definitions, but I believe that the more used is the one that says that intelligence is the capability of an agent, which is a piece of software, to solve a problem by finding new solutions. And here at the end we have the definition of intelligence, let's say, from more a biological point of view, which is the capability, the mental capability to reason, to plan, to solve problems, to think in an abstract way, to comprehend a complex idea, and to learn quickly from experience. If we put it together, the word artificial and intelligence, a complete new horizon or panorama is open to our eyes. This was done by John McCarthy in the late 50s, who was a professor in Stanford, at the Stanford University, and the other pioneer in the field of artificial intelligence is, as everybody I believe knows, it is Alan Turing, that he was the creator and developer of the Enigma machine, and he created the first machine able to play against a human. And this is the famous imitation game that was also the subject of a quite famous movie. And then, not by Alan Turing, but inspired by Alan Turing, there is a kind of matrix which is associated to the concept of artificial intelligence, that it is related how good is reasoning a computing machine by interacting with a human being without the human being realizing that actually he is speaking, is playing, or is doing whatever he's doing together with the man, together with the human brain. But the concept of John McCarthy, it is that he defined artificial intelligence as the science of making intelligent machines. What are basically intelligent machine? It is a machine that simulates the behavior of a human brain in trying to solve generically a problem. This we skip. In the 2018, it is also an important date because the high-level expert group of the European Commission's Union gave a definition of what it is meant for us in Europe, what is meant for intelligence and for artificial intelligence. The operation that was doing is simply substituting the word intelligence with the word rationality, because the word intelligent is per se a very broad concept. Instead, the concept of rationality is much better confined and is much better defined. And basically, rationality, it is we have an environment, a surrounding environment that is surrounding our agent I mean internal software, and this agent realizes the characteristics of the environment by signals which are coming from sensors, and basically with the signals which are coming from sensors, then together with this reasoning realize the characteristic of the surrounding environment, and is also able to realize how to act in order to change this environment. So we have a piece of software, we have sensors, and we have actuators, and we have a surrounding environment. More or less, this is the definition that was given by the European Commission, in essence. The other definition that was given by this expert group, high-level expert group, it is the difference between structured data and unstructured data. Structured data are data which are organized according to a very specific structure. Instead, a narrow, oh, sorry, but maybe it was not. This is, okay. Instead, the unstructured data, instead the narrow artificial intelligence is a type of intelligence that interact with a specific task. And it is developed in order to solve or to perform a specific task. Okay. Artificial intelligence, we have to see as a software, as a computer program which is able to simulate a behavior. So artificial intelligence are considered as software to simulate something. In this case, to simulate the behavior of the human brain faced with determined problems. The artificial intelligence comprises also what is called machine learning. Machine learning are the set of data and the algorithm that we are using to train our data, to train our intelligence. So we have always different phases. We have the first phase in which we define the mathematical algorithm or the simulation model that we will use to simulate a specific system. Then we have the phase of machine learning, which is the phase that we use to train our artificial intelligence, and then the machine learning, the phase of training or simulation can be implemented using different type of algorithms. This can be supervised algorithm, this can be unsupervised algorithm, and or they can be of the type of which is called deep learning, which is implemented using an artificial neural network. Artificial neural network, that is a type of training which is, or the machine learning algorithm, which is very flexible because compared with the other type of algorithm used for training, it needs a lot of, a very large quantity of data. I'm going very fast because these are all things that are known. Then we have supervised and unsupervised machine learning. Which is the difference? Of course, any time that we train a machine or we train a system, we provide this system with historical data. These historical data are configured in such a way that our machine will be able to perform certain type of predictions. And the type of predictions that we want our machine able to do are provided by us before the phase of training. And supervised machine learning, it is a type of machine learning where we give to our machine the type of prediction that we want the machine able to do it at the end of the training phase or the learning phase. Unsupervised machine learning, instead, we provide a large amount of data to our machine, but we don't say to this machine what type of prediction we want the machine doing. So the machine will discover by itself the type of prediction that we want the machine doing at the end of the training phase. For example, the supervised machine learning, that it is an artificial system able to analyze in order to make diagnostic images, medical images, we will say we are looking for this type of pattern. Can be the pattern of, I don't know, a kidney disease, a kidney cancer, or can be any type of other disease. But we say to the machine what type of pattern we want the machine will discover at the end. In the supervised machine learning, we don't say to the machine, to our artificial intelligence, which type of pattern we want the machine discover at the end of the training phase. But the machine itself will see and will identify patterns which are hidden in the middle or our training data. This is basically the difference. Another type of learning, the last type of learning, which is not very much used anyway so far, it is the reinforcement learning. Reinforcement learning works as a cost function, in the sense we have our artificial intelligence, our model, our mathematical algorithm, we provide him with data. And once that we provide the data, we see what type of answer we get from the machine. if it will be within a certain type of accuracy or not. For any failure, we give a penalty. For any success, we give a reward. At the end, we count the pointings made by the reinforcement learning. And if this cost, which we define as a cost function, if, let's say, the final pointing is above a certain threshold, then we say, okay, the learning is done. Otherwise, we continue iteratively to provide always new data. So basically, reinforcement learning works together with the cost function. This is more or less what should be known in order to understand what the process of artificial intelligence. Now we go how the EPO, the European Patent Office, behaves when he has to face with an application in the field of artificial intelligence. Normally, we have said before that artificial intelligence applications are simulation, model and simulation mathematical algorithm. So then we can define artificial intelligence as a subdomain of computer science. Being a subdomain of computer science, then we apply a reasoning which is called computer implemented invention. And the computer implemented invention are basically define all the type of claims or invention which include at least one feature that it is implemented using a computer network, or a computer program, which are all subject matter that the European Patent Office, according to certain situation, is granting. You can get a patent for a computer, you can get a patent for a program. You can also get a patent, for example, for the signal which is downloading the program from one machine to another machine. This is also patentable. And the way in which the examination is performed at the European Patent Office for computer implemented invention, it is known as a two hurdles process. What does it mean, two hurdle process? When the European Patent Office examiner gets a patent as a computer patent implemented invention, he will check first if this patent is eligible for having granted a patent. What does it mean, eligible? It means that it must include subject matter which is not excluded from patentability. If the second hurdle, or the second phase, it is that this fantomatic examiner of the European Patent Office will check, will check if the subject matter included is patentable. Patentable means that it must be novel, inventive, and industrially applicable. I will not have time to enter in how this is defined, but basically the main requirement that the European Patent Office wants in order to grant a patent for a computer implemented invention, it is that it must have a technical character. The European Patent Office, as always, does not tell you what is technical character, but tells you what is not technical character. This is defined in Article 52, 2 and 3, and in the guideline. But if you read the guidelines, checking the guideline, you have the definition of what it is. Basically, what it is considered as having a technical character is a feature of a claim that includes or requires the use of a computer in order to be performed. We can say that this is a main requirement. And how it is done and how it is checked by the examiner. The examiner reads the claim, divided the claim between features that have technical character and features that they do not have a technical character. The feature that they do not have a technical character, they do not give any contribution to the technical character of the whole invention, and it considers only the feature having technical character. The feature having technical character are put together. It will be checked whether they solve in a novel and inventive way a technical problem. If yes, the patent is granted, which appears simple, but sometimes there are a lot of discussion involved. This technique has been found by the president of the chairman of the Board of Appeal 351, Mr. Steinbrenner, that and is defined and described in the convict decision, which is the TSA 641/00. Okay, then we just very quickly, we see what is the application. We see some of the application of artificial intelligence. Artificial intelligence is a technology which is very pervasive. I don't believe there is piece of software or a piece of device. It can be a washing machine, can be a dishwashing machine, can be whatever it is that does not have a piece of a chip or a piece of software implementing a piece of artificial intelligence. And normally there are applications of artificial intelligence in the automotive, in robotics, automation, natural language processing, speech processing, etc., etc. The things that was interesting to me, it is in health informatics, in diagnostic, patient therapy, etc., etc. Here I put some examples. I was underlined the Da Vinci robot, which is very, very old, but at the same time very meaningful. Alexa, Siri, I don't know. These are all applications of artificial intelligence. Microsure, Apple Watch. In Apple Watch you have this process for analyzing the ECG and etc., etc. I'm sorry that there is no time for giving you with more detail. Okay, speaking the other time you were speaking about the fifth industrial revolution. I saw it only yesterday that now we had the Internet of Things and now we have Internet of everything, which I found very, very funny. Okay, as a conclusion, speaking about also the financial resources that there are, we have a huge amount of investment which is coming not only in artificial intelligence but is coming in application of health informatics. We are speaking of billions of euro that will be spent in Europe till the 2025, and this was a prediction, and this prediction has been already overcome. So anybody that wants to invest in health informatics, I would strongly recommend. And there is a sentence which I would like to remind you, which is from Professor Agrawal, which is one of the guru of artificial intelligence, that was given to McKinsey Publishing in the April 2018. what he was saying it is that artificial intelligence lower the cost of prediction, making possible to predict faster, better, and cheaper, and to solve via prediction also problems not traditionally associated with prediction, like, for example, autonomous driving. If we want to have a car driven automatically, we must know where there are the traffic lights, we must know where are the cross lines. So this is also prediction. And the progress of artificial intelligence is exponential. It's not anymore linear, and it is based on the very powerful capability that artificial intelligence has to learn. Because this is the point. Systems with artificial intelligence, they are able to predict, to make prediction, and to make and to learning how to make a new prediction. Thank you very much.
Thank you so much, Michelangelo. And we would like to thank you with this memento as well. All right, thank you so much, everyone. And with this, we just concluded our informative, fun, and friendly 2 IIPLA days. In the last 2 days of IIPLA 2023 Dubai, we discussed the various forms of intellectual property and the importance of protecting them. We covered major IP topics, including patents, trademarks, copyrights, and to some extent, trade secrets as well. And we understood how they can be used to protect a business's unique ideas and creations. We also discussed the potential challenges and controversies surrounding intellectual property, such as the balance between protecting rights holders and promoting innovations and access to information. We emphasized the importance of understanding the complexities of intellectual property law and seeking professional advice when necessary. Furthermore, we have highlighted the significance of internet and technology in the current intellectual property landscape. We talked about the correlation of fifth industrial revolution and intellectual property, IP protection and IP strategy, IP in NFTs and metaverse, IP in AI and ML, and IP challenges in the future of IoT. With the increasing ease of sharing and distributing information online, it is more important than ever to understand and protect one's intellectual property rights. It is also crucial to be aware of potential infringement of others' rights and comply with trademark laws when using brand names across the border. Now, in conclusion, protecting one's intellectual property is essential for any business or individual looking to monetize their unique ideas and creations. It's important to be aware of the various forms of intellectual property and how they can be used to protect those rights. Additionally, with the internet and technology constantly evolving, it's important to stay informed and up to date on the latest developments in intellectual property law. We encourage all the attendees to seek professional advice and to continue learning about this important subject. Thank you for joining us for the IIPLA Dubai event. We hope you found it informative and valuable. Remember, protecting your intellectual property is vital for the success of your business or individual endeavors. And yes, most important, don't forget to explore Dubai, the beautiful desert city. We hope to see you again at IIPLA 2023 USA in the coming October. Till then, take care and have a safe trip back home if you're flying outside Dubai. Thank you. So, could you please briefly introduce yourself and what you do?
Okay, sure. This is Henrietta Newton-Martin with you, a senior legal counsel and also faculty in law.
And how's your experience at the IIPLA 2023
Well,
Dubai?
I enjoyed it a lot. It was quite informative, and you had wonderful speakers who had well researched. It was really a pleasant experience, expressing my opinion as well as learning.
So would you recommend it to the other?
Of course.
All right, great. Thank you so much
Pleasure.
for participating with us. We look forward to seeing you again. Take
Sure.
care.
Take care.
Hey, could you please introduce yourself briefly to our audience?
Yes, my name is Chris Jeffrey. I'm the Director of Customer Success for We Localize, covering Europe and Asia. This is our first visit to Dubai, to IIPLA, and we're excited to be here.
Great. How do you like this conference?
Very good. It's an area we've been looking at for some time, and the speakers at the event were fantastic. We're actually looking forward to being a speaker ourselves next year.
Definitely.
We've been here all across the 2 days to all of the sessions, and we're really excited about being a speaker next year.
I'm glad that you like it.
Hopefully help the audience in terms of explaining how we can support IP and contribute to IP in the United Arab Emirates as well.
Well, definitely we'll keep in touch and then hopefully get something interesting by the next year. Thank you so much for attending it.
Thank you very much. Thank you.
Bye-bye.
How was your experience as an exhibitor?
So it was a fantastic experience being here at IPLA. It was the first time for CountCheck to be in Dubai, and the event was a really great place to network with IP professionals and for us to showcase the new technology of CountCheck and how we're helping revolutionize the block of counterfeit goods and make a safer place.
Thank you very much. I have attended many conferences, but this one is a very unique and informative one. And the things I have learned from here, it's blockchain. And blockchain conferences, blockchain informative lecture is very interactive and very informative for me. And I have learned about how to convert intellectual property into blockchain. And already I was doing a job and doing this idea and working since 2020 on blockchain. And I have attained a degree from USA in blockchain. And my thesis was how to convert intellectual property into blockchain. And many speakers here also give a detailed lecture about blockchain and intellectual property, and really wonderful and informative for me in this kind of things. Thank you very much. My great takeaway is my network. Yeah, I have managed many colleagues and clients, and many my fellows, which I have met before COVID, and now it is very interesting to keep in touch with that great guys. Thank you. Really, I will really recommend the IPLA to my colleagues, to my clients, and my associates as well. And definitely, I will join in next upcoming IIPLA conference. Thank you very much. My pleasure, my pleasure. It's a nice to meet. Nice to meet. Thank you very much. Thank you.